Great. So I'd like to call this meeting to order. Pam, will you please do a roll call vote?
I will. Good morning. Member Bitzer, are you present?
I am indeed.
Very good. Member Carrasco, he did send us a note, but just for the record, I wanted to call his name. He will be absent. Member Curry.
Here.
Thank you. Good morning. Chair Ely.
Present.
Member Garcia.
Here.
Vice Chair Sweeney.
I'm here as well.
Very good. Thank you. Madam Chair, you have a quorum.
Great. Thank you very much. We do have an agenda for today. Do we have a motion to approve that agenda?
I move we approve the agenda.
I second.
Okay. Let's roll call that one too, Pam.
Okay. Member Bitzer, your vote?
I vote yes.
Very good. Member Curry?
Yes.
Thank you. Chair Ely?
Yes.
Member Garcia?
Yes.
Vice Chair Sweeney?
Yes.
The motion to approve the agenda passes.
Great. Item number 3 on the agenda is public comment. I do want to note that we will be taking public comment on the AFFF during the hearing itself, but if anybody wants to provide comment now, they can. So is there anybody who would like to provide general public comment for the board? Yes, sir. Please come forward. One second, sir. Please use the microphone so we can all hear you. Yeah, thank you. No problem.
Buenos días de la Dios. My name is Chaplain Jose Villegas. On behalf of the La Cienega.
One moment,
Yes,
sir.
ma'am.
I think it is. Sir, is this a public comment in related to the firefighting phone?
Yes, ma'am.
Okay. So I'd like you to please spell your name, or Felicia, do you want to manage that? Yeah.
Sorry. Thank you, David, for beginning the transcription. We're about to accept public comment in EIB 25-81 relating to Aqueous foam. Would you state your name, please, and spell your first and last name?
Yes, my first name is Jose, Joac, L for Lorenzo, Lorenzo. Last name Villegas, V like in victory, Illegas.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, please go ahead.
Buenos días de la Dios, and good morning. My name is Jose Lorenzo Villegas Sr. On behalf of the La Cienega Land Grant Association and the Texas Band of Yaqui Indians, I'd like to present this short presentation of this serious situation that's going on in my community. As someone who is directly affected by the contamination of my blood due to this firefighting foam in my body and the contamination of our private wells by the DOD and New Mexico Army National Guard Aviation Support Facility located in Santa Fe, I see firsthand how the current system falls short and how this rule would make a meaningful difference in innocent people's lives in New Mexico. The proposed rule, if adopted, will help protect vulnerable populations, improve access to clean, safe drinking standards, strengthen accountability among the masses of chemical industries not adhering in protecting our environment and our precious water resources. The improvements are not, or these improvements are not abstract. they would possibly impact real people's lives, like me and my community every day. I appreciate that the New Mexico Environment Department Cabinet Secretary James Kenney has been proactive with the La Cienega land grant community by intervening in addressing our PFAS contamination, especially the firefighting foam contamination of our private wells in the last few months. He has truly kept his word to protect our best interests of public health, welfare, and safety for all New Mexico. Finalizing this rule will demonstrate a commitment to fairness and evidence-based solutions regarding what is best for the state of New Mexico from the environmental justice perspective. I encourage that the EIB to finalize this rule as proposed. It is a good policy decision on behalf of all New Mexicans. I am sick. My blood is contaminated. It is in my system. I had just surgery to remove some things off my body. I'm a vet and marine. I don't deserve this. Neither does my wife and my children and my community. It's some serious stuff. So do the right thing. Muchas gracias and blessings to each one of you.
Thank you very much, Mr. DiLorenzo. We're going to hold other public comment in EIB 2581 until we actually begin that hearing, which will be following the deliberations in EIB 2577. Sir?
Does the board have time?
Are you not going to wait until we get to the hearing?
I feel it works. I can wait.
You can wait. All right. Thank you very much. All right. Madam Chair, will our court reporter, I'm certain, will add that to the transcript in 2581. So go ahead.
Thank you, Madam Hearing Officer. Is there any other general comment? As noted by the hearing officer, we will take public comment on the firefighting foam rule later today, but thank you, sir, very much for your comment this morning. But if there's any other general comment for the board, we could take it now. All right, thank you so much. The next item on the agenda is deliberation in the matter of proposed repeal and replacement of 20.2.71 NMAC operating permit emission fees and 20.2.75 NMAC construction permit fees. And just to reiterate once again, after we finish this deliberation, we'll move right into the hearing on the firefighting foam. So we concluded the hearing last month on March 25th after 2.5 days of testimony. And at that time, the board opted to hold deliberations this morning on the air quality permit fees. Since that time, the parties have submitted closing arguments and statement of reasons, and they met the deadline of Thursday, April 9th. And so we have those documents to refer to as we move forward with our deliberations. I just also want to note that we do have translation, and I'd like to invite the translator to provide instructions on that. I should have done that earlier.
Hello, everybody. There is interpretation available on the WebEx channel. If you go to the bottom part of the screen and click the globe, you can choose between the English and the Spanish channel. You can switch between either of the two during the hearing if you would like to hear the Spanish interpretation over WebEx. If you are here in person, please come up to where I am sitting and I can provide you with a headset to listen to the Spanish interpretation. Buenos días, tenemos disponible la interpretación al español. Si se encuentran en la plataforma WebEx, por favor vayan a la parte inferior de la pantalla, van a ver un globo terráqueo. Ahí oprimen y pueden escoger el canal del inglés o el canal de español. Pueden escoger cualquiera de los dos durante la audiencia, y si están aquí en persona, vengan a pedirme el equipo de interpretación y los audífonos y se los proporcionamos aquí en persona. Gracias.
I'd also like to note that we have sign language today for this for these deliberations and the hearing. Okay, so board members, we have a quorum. I hope you're all ready to deliberate on the air quality permit fees. I would like to open it up for suggestions about how to go about the deliberations. I have some ideas, but if you have others, I'd like to hear them, please. So may I suggest that we open up a discussion with a few high-level questions, and then, as we have in the past, and then go through the markups and make some decisions on some of the proposed language based on the discussion, high-level discussion. Does that sound agreeable to the board members? I see Member Garcia nodding. Mr. Bitzer, Mr. Curry, great. I see Mr. Bitzer with a thumbs up. Mr. Curry, great. And Phoebe's on her way, so we'll take the 4 out of 5 board members' opinion on that.
Yes, I agree.
Oh, thank you, Vice Chair Sweeney. So in 2024, we held a fees hearing, and the board unanimously decided not to adopt those fees, that fee proposal. At the time, we didn't believe we had sufficient evidence to determine whether the proposal was reasonable or not. And so I want to ask the board just a general question. Do you feel like you have sufficient evidence at this time to make a determination as to whether the proposed fee increase is reasonable and sufficient to cover the cost of the program?
Yes.
Mr. Curry, Mr. Bitzer?
I'd say it's a close call either way. I'm open to further discussion on this. I agree.
I feel comfortable going forward as well.
Yeah, me too. As stated during the hearing, I feel NMAD was responsive to our concerns. In 2024, we really didn't have evidence to make a decision. And this time around, they did go back and provide us some of the really key information I felt like we needed. One was cost estimates going forward, revenue projections going forward, and the business as usual scenario, meaning what would happen if we didn't move forward with a fee proposal. So I do agree that at this point, I feel like I have enough information to make a decision on these rules. Right. And then one of the next kind of general questions is there a need to increase the fees in the proposed, and are the proposed fees sufficient to cover the costs of the program as described by the department?
If I may, this is Member Garcia. Yes, I think the department abundantly demonstrated a need to raise fees in order to administer the program effectively. And I can understand that it's been difficult for the last few years since the fees were raised. It's been 2009, 2003. So I think the department did a good job providing evidence to support the need and the fact that reviews are more complicated, technology is more complicated, more monitoring needs to happen. They need to buy more monitors. There was lots of information provided to show a great need for raising the fees. Thank you.
Member Bitzer?
I would concur that there needs to be a fee increase. The question is, are we throwing a dart in the dark at that amount and that timeline. So, but I guess that comes a little further down the road where they've presented as a plan B alternate the more graduated annual review based potential adjustments to the fees as needed. So that's, I think, where things are going to get interesting. That's all I've got.
Yeah, I would like to go into a deeper dive about the numbers after we have this initial discussion. Member Curry, did I see your finger go up?
Yeah, thank you, Chairman. To Mr. Bitzer's point, I think we've received a lot of evidence. I think it's incumbent upon the department going forward, no matter whether the increase is supported or not, to be able to show a very strong audit trail, I guess I would call it. So to demonstrate exactly how the fees are being spent. And I know that can be challenging at times, but I think that would cause more buy-in from the regulated community.
Thank you for that comment. Vice Chair Sweeney.
Thank you, Madam Chair. I think I feel comfortable going forward, and having participated in the previous rulemaking hearing when the board did not approve of the fees at that point, and given the comparison between what the department presented during the hearing, and not just during the hearing, but also in the written material, I feel comfortable going forward, and I feel like I have enough for discussion, as Member Bitzers mentioned, as we continue to deliberate on the specifics of what was proposed and what has been proposed by all parties, and in particular by NMAD.
Yeah, I was convinced by the department's testimony that without an increase in fees, they would have a hard time protecting public health and the environment. Particularly interested in compliance management strategies or monitoring strategies, and how many inspections the department is behind on, how many they need to conduct. The pressure from EPA to get those done, those are EPA numbers that they have to meet, and they are nowhere close to that. We need to get more inspectors out there. We need to support the department as they move forward with Part 70, the ozone precursor rule. The stack tests related to that are astronomical, and they cannot review it without additional funds and staffing to get that done. I'm also quite concerned about ozone non-attainment in the northwest corner and the southeast corners of the state, and they're going to really need to ramp up if there is a formal designation on that. So I think they did a great case and in describing the real needs out there. And so, yes, I think the need is there, and I think the fees they are proposing, they demonstrated that what is being proposed will cover the costs of the program to meet all those particular current and future needs. So now I'd like to, if you don't mind, I'd like to talk about the actual proposed increase for both the construction program and the Title V fees. And potentially, maybe we could start with emission fees in Part 71, which is the Title V program. The department is proposing to increase the cost per ton from $20 to $85. And I say $20 because those are the numbers in the rule. But if you actually look at the cost with inflation adjustments, it's more like $41 to $85. So to an increase, but not as dramatic as 20 to 85. The New Mexico Mining Association proposes no increase at all. And the NMOGA public comment submittal, they did not provide testimony, but they did provide written public comment, is proposing an increase of $60. Member Bitzer, you have your hand up. Member Bitzer, I think you're on mute still.
Sorry about that. Probably should have brought this up earlier when you were asking about how steps in the process. But it occurs to me that on like page 20 of the rebuttal document that they're questioning the legal authority. And so I wanted to check with counsel and get his take on that before because if he suggests that maybe we're exceeding our authority, separation of powers argument was made in there. Starting page 20 and I think go back to 23, I think. Yeah, counsel, did you get a chance to review this?
Yeah.
Yes, Member Bitzer, I did.
What's your legal opinion about whether we have the authority within the separation of powers argument and such that they've made?
In my view, I think the statute is clear that the EIB does have the authority to develop fees in various circumstances, including the ones that were proposed here.
All righty. Sorry to jump out of order then. Just wanted to make sure that if there was concern about that we didn't go down a rabbit hole that we didn't need to. So.
No need to apologize. That's a foundational question. I appreciate you bringing that up. Any other questions around the process before we start talking about Title V operating fees? So the question is the increase from $40.59 to $85 per ton a reasonable increase for operating fees?
Thank you, Chair Ely. I just have a procedural question. As far as how we're going to go through this, did we want to go through each part of the rule, or I see you're jumping into the actual fees, and that's fine. Is that how you want to do that?
Well, I was thinking if we could kind of get a sense of where we're at on whether the fees are reasonable, whether we needed to increase them, then we could go. I thought we'd just go into the industry markup after that and not go through each portion of the department's rule, but I'm open to ideas. If you want to go through the department's markup, we can do that too.
Thank you. No, I think the way you're approaching it is perfect. I think that'll be fine to a general question about the Environment Department proposal and then go into the markup for Mining Association. Sounds good. Thank you.
Vice Chair Sweeney?
Yeah, thank you. And I guess maybe to open up discussion regarding the increase, again, going back to 2024 and when we were reviewing this, I think the information provided by the department, both written and verbal, provided me more information to justify and have a basis for that increase. I think it's for like you said, $40.59 per ton, revising it up to $85 per ton. I understand also, some of the comments and written material from industry that when you look at that is a large percentage. That said, is there's been lack of an increase for years. And again, to your points earlier, Chair, is there's a real need right now, as shared by the department, to have the resources to have a program that is adequate and is addresses some of, that going forward, some of those deficiencies in staff and resources need to be addressed in order to have a good program. So I can understand where as the department has presented during the hearing, that justification for that increase. Thank you.
Member Garcia.
Thank you. I agree with Vice Chair Sweeney, and I just wanted to add, I think the jump to 85 is reasonable. It would cover the reasonable cost. I think the cost has increased dramatically since the last fee increase, and the last round when the Environment Department came to us for a fee increase, they demonstrated a need. There was no question about that. It's just that there wasn't the detailed information or evidence to support why they chose the numbers they chose, and how the money was going to be spent. Some of the questions I remember asking, I didn't have an adequate answer. This time I did. I had a question regarding the database that was answered much more clearly this round, and how the money would be spent. And I understand the time for reviewing applications, et cetera, is increased over time, and I think that increase, the fee amount increase, and the fact that the changes to PM 10 and PM 2.5, that wasn't even, the industry wasn't even charged for many years, I think since 2018. So the industry got a free pass on that for a while. So I think this is entirely reasonable, in my opinion. Thank you.
Yeah, I do also want to discuss the particulate matter issue too. And that's my recollection too, Member Garcia, is that industry has not been charged for particulate matter since 2018, leaving a hole of $2.5 million that should have been collected by the department. But because particulate or TSP, total suspended particulates, were rescinded in 2018, they couldn't charge for them. They are proposing to charge now for PM 2.5 and PM 10, whichever is larger, not both, whichever is larger, and as well as put a cap of 3,000 tons per year on what would be charged. Do want to note that in 2024 they proposed removing that cap completely. So they did their analysis. I think this is a more reasonable approach to have a cap of 3,000 tons per year, down from the 6,000 tons per year that's currently in the rule. And the reason for that is so that as I understand it, is so that one or two companies don't pay the majority of the fees. So I believe their approach to charging for Title V fees is reasonable, and I would support adopting that section of the rule as drafted by the department. Mr. Curry or Member Curry or Member Bitzer, any other comments on Part 71 fees before we go on?
I would concur that that a substantial increase is warranted. Again, I think maybe we're throwing a dart. I'm wondering out loud if it turns out that there are fee accumulations that have risk of getting swept, whether they what the timeline would be for industry. I sort of made a combined acronym for them: NMAC AOGA IPA what their timeline would be if they wanted to petition us for a redress of grievance here on the idea that maybe we're getting overcharged for fees. We're not able to spend that money. And so anyway, given that there's notification timelines and so forth, there would be a certain amount of interval before we could act on their behalf. And so I just want to put that out there in terms of how long it would take, just more as a question for thought, to walk it back a bit if we go all in now, and it turns out we're overcharging, how that would look. Just a thought.
Vice Chair Sweeney.
Yeah, thank you for that, Member Bitzer. And I think I think one of us did ask the department and brought up some discussion regarding, I guess, review, the annual review. I know initially it was, one of the annual reviews were initially taken out of the role, and then upon some comments and discussion, it was, I believe the department put back in language regarding the annual reviews and administrative compliance costs. And so the department did add the annual review requirement, I think in revised part 75. So I think one of for me, what makes me feel a little more comfortable is that there are milestones in the overall process where the department, maybe even the board, has information as well as the industry to see how the program is kind of proceeding, and to address some of those concerns as you raised, to make sure that we're not overcharging industry, or that there is some balance as we go forward, as well as was it enough? So, only as we go forward with the program, those checks are really important to make sure that it is a balanced process going forward, and uh, um, both the regulated community as well as the regulators can come and continue to assess that. So I don't know if anybody has any other comments on that, or if I'm wrong on that.
Member Garcia.
Thank you. And thank you, Member Bitzer, for bringing up a very important point. And I know the industry brought up the point as well, that perhaps there'll be money left in the bank that is not being spent because it's not needed, or the legislature could sweep funds. And having been in state government for many years, I know that the legislature can sweep funds at any time. It doesn't matter if we have a $5 increase or a $40 increase. The legislature does that from time to time. We have no control over that. So that could happen, and it probably will. But for our job, it's just a matter of determining, to me, it's a matter of determining if we need to do our job in making sure the department has the fees necessary to cover the reasonable cost of implementing the program. And so since we didn't raise them last time, and we made sure that there was proper evidence to support an increase, I think that your concerns are valid. However, I think that I feel that the department did a good job explaining the interaction with DFA and the legislature, and how we know DFA is extremely strict about how money is spent and how much money has to be in the coffers to cover the cost of running the program at any point in time. DFA is ridiculously strict about those things. I know, I've lived there. So so I guess I'm not concerned about that issue myself. Thank you.
I too want to comment on Member Bitzer's statement about industry being able to come back and petition the board if they feel that the fees are too high. Anybody can petition the board, any member of the public, and it doesn't necessarily have to be the department that comes back to lower the fees. If industry is unhappy with how the rules are being implemented or believes the fees are too high, they can come back and request a change in the fees, not just the department. I do want to note one thing though, and that is Title V fees are highly regulated by the federal government. Those fees were swept before, but they had to be replaced because EPA was not happy.
I'm trying to get in actually.
Excuse me, please put your mic on mute. Who's ever on the platform speaking, thank you. So anyways, but the construction permit fees were swept and they were not replaced, and that could happen again in future. So at this point, I just want to take just kind of a general vote. We'll go through the markup, but just a general vote on how comfortable the board is with the proposed increase in fees for Part 71. Would somebody like to make a motion for the board on that?
Chair.
Yes, Vice Chair Sweeney.
So let's see, for just Part 71, are you asking? Okay. I want to make a motion that, are you looking for a motion to accept the increase or to support the increase?
I just want to get a feel for the board to see if they're comfortable with the increase in the dollar amount, the cap as it is, and including particulates as drafted by the department. Those seem to be some of the three issues that were contested by industry. And I just want, before we go into the markup, see where the board is on that. I think it will help us walk through the markup maybe a little easier if we have an understanding of where the board sits on that matter.
Make a motion to support NMAD's proposal for Part 71 increase or the cap as proposed by the department. And what was the last?
Inclusion of particulate matters and the dollar amount.
Inclusion of the particulate matters and the dollar amount as proposed and supported by NMAD.
I would second that motion.
Any further discussion on before we have a vote? Pam, could you do a roll call vote on that?
I will. On Vice Chair Sweeney's motion, Member Bitzer, how do you vote?
I vote yes.
And Member Curry,
Generally, yes.
Chair Ely,
Yes.
Member Garcia,
Yes.
Vice Chair Sweeney.
Yes.
The motion passes.
Thank you for that. I'd now like to move on to construction permit fees in Part 75. So what the department is proposing are a few things. One is well, let me back up for a second. So as you all know, as a permit is being reviewed, it is assigned points based on the type of review that is needed. The department is proposing to increase those points for a few types of permits and a portion of the review. One is to increase the modeling review from 15 to 30 points, and oil and gas general construction permits from 10 to 30 points. They're also adding notices of intent for that point system, and proposing to increase the dollar amount per point. So maybe we could start with the point system. I didn't see that anybody opposed the modeling increase from 15 to 30 points for that review. NMOGA is opposing the 10 to 30 points for the oil and gas GCPs, or general construction permits. They're suggesting that that should be 20 points instead of 30. So maybe if there's we could have a little bit of a discussion around that particular issue in the point system. I do note that last time in 2024, the department was proposing 50 points for the GCP, and they could not explain why, which exasperated me, how they ended up with 50 points for that. This time they went back and looked at the work required to process that type of permit and decided that 30 points was the reasonable level for doing that. NMOGA's 20 points is something we could discuss, but I didn't see really any evidence in their written public comment, not testimony, but in their written public comment, really justifying the change from 30 to 20 points for that particular type of permit. Chair, Vice Chair.
Thank you for that summary, and I just wanted to share my thoughts. I think to some of the last points you made, I think the department in this hearing was able to provide additional information that we didn't have in the first hearing. And as you indicated, Chair, it went from the initial proposal of 50 to 30. And again, with more information supporting that proposed change this time around. I just wanted to highlight that we do have that information this time around.
Any other discussion on that? I'm comfortable keeping it at the 30 points. I think you could probably tell from my statement. I think that's an appropriate level. I do have to harken back to this point system that was developed by the section chief at the time years ago, and it seemed kind of outrageous to do that and complicated, and now 25 years later, I think it's a great system. I think assigning points so that industry, pays for the work required to implement that permit, to process it and implement it, is a really good thing, so that an oil and gas GCP pays more than, say, an aggregate GCP. I think that makes a lot of sense to me.
Thank you, Chair and Vice Chair. I agree with both your comments. I don't have anything else to add. I think that changing it to 30 points is appropriate.
So are the board members generally comfortable with the 30 points for oil and gas GCPs? I see a thumbs up from Member Bitzer and Member Curry. Thank you. One of the other big changes to the point system is adding notices of intent. I had no idea that notices of intent compromise 30% of the emissions in the state of New Mexico. They're smaller sources, but there's so many of them. They really accumulate into a lot of emissions. They used to pay an application fee, but now they'll be part of the point system under the proposal, and they'll also be paying an annual fee as part of the proposal. Do the board members have any concerns about the department's approach to notices of intent.
I think that approach is appropriate. Thank you.
Member Bitzer, do you have any comments? You're okay with it? Okay. And Member Curry, good.
And Chair Ely,
Uh-huh.
I'm also comfortable with that as well.
Okay. So the other change, as I mentioned previously, was an increase to the multiplier for each point. Currently, it's the draft rule has a multiplier of 315, or not the draft rule, the current rule has a multiplier of $315. They're proposing to increase it to $585. But if you look at that number after adjusted for inflation for the CPI for the many years this rule has been in place, the actual current cost per point is $539. So there's about a 9% increase is what the department is proposing. The New Mexico Mining Association proposes no increase per point, and NMOGA was silent on that. They didn't make any statement on that in their public comments that they submitted to the board. 9% increase seems reasonable to me. I'm just curious what the other board members think. I see heads shaking yes.
Yes, and I think I acknowledge the Mining Association's comment and proposal of no increase, but that seems not reasonable to me as well. So I just want to also state that 9% also seems reasonable.
Member Bitzer?
Yeah, I was just impressed by your economic analysis, doing the inflation adjusted math. It's like, are you testifying as a expert? And if so, what are your credentials and how long have you been an economist?
Member Bitzer, I just pulled it from testimony. You don't want me to be your economic expert on in any hearing. I guarantee that. Yeah. But it makes a difference to me because then you get a sense of how much it really is increasing. If you look at just the number in the rule, 315 to 585 looks like a huge jump. But since they've been increasing this number over time, that number is really much closer than it appears in the rule. So, and I could say the same about the annual fee. NMED is proposing an increase to $2,800 for the annual fee for the permits. But again, after inflation, it's $2,564, which is again about a 9% increase, which seems like a reasonable increase to me. And I'm wondering, yeah, I see Member Garcia shaking her head yes. I'm wondering, Chair Sweeney and Vice Chair Sweeney and others, if you have an opinion on that. I see thumbs up from Member Bitzer. Member Curry? Thumbs up too. Okay. And then lastly, as far as discussion, NMED is proposing an annual fee of NOIs of $700. That's new. NOIs did not have an annual fee before. The New Mexico Mining Association is opposing that annual fee. Is opposing an increase in an annual fee. So they're opposing an increase in an annual fee as well as even charging an annual fee for NOIs. They're opposing both of those issues. To me, you know, NOIs are, as I noted, a large source of emissions. There are many of them out there. They still have to be accepted and processed and enforced. It's not voluntary. It's not a voluntary program. People have to come in for those applications, and so I think it is highly appropriate for an annual fee to be charged for notices of intent. And I'm just wondering if the board members feel the same.
Thank you. I agree with you, Chair Ely, that it's appropriate to have a annual fee. They probably should have had before, and the volume, I was surprised also at the volume of NOIs. So it seems entirely appropriate to me.
Yes, I agree with both the chair and member Garcia on your comments, and I support the annual fee for the NOI.
Thank you for that. They are a quarter of the fee for the other, as charged by the other programs. I see a thumbs up, I think, from member Curry and member Bitzer. Okay, great. Are there any other particular points that the board wants to talk about kind of at a higher level before we go into the markup of the rule? And again, yes, member Garcia.
Thank you. I just wanted to point out one issue that I had a little trouble with, and I did have questions during the hearing regarding the department, including a new section C that would provide the discretion to increase additional points and fees when they had to repeat reviews and industry's application would change through time, and then they had to spend more time. The problem I had with it is that industry needs certainty. They need to know exactly what they're going to be charged when, and this was a little bit hard to understand when would that threshold be crossed. It didn't seem quite fair. However, I do remember the testimony that the department has always had this discretion, and they haven't been using it before. And this way, it's more, at least it's pointed out in the rule a little more clearly, and the department still has discretion. They always have enforcement discretion. And so I think this puts industry on notice that they can't keep changing applications in the middle of the review continually. It does take a lot of time, and it's very frustrating for the department. So I, in the end, after reviewing information, I decided that I agree with that section, that new section C. Thank you.
Any other comments about that new section C? Yeah, I think it's appropriate too. If they have to put more work into it, the applicant should be charged for that. The other thing, it didn't really come up in testimony, but the department has a very specific time frame to issue these permits. And if people keep coming back, they're going to bump up against that time frame and they may miss it. And it's statutory. It's not even just in the rules. It's a statutory time frame of 90 days to get these permits out the door. So that's the other problem with people continuing to come back and changing their applications. Provides more work for staff that they may not or may not get covered by the fees, and then they may miss their statutory timeline for getting those permits out the door. So I agree that it's a good change in the rule. Member Curry.
Yes, to add to that as well, going back into the day where some of those specifications that you just spoke of were put into place in the early 2000s because the department at the time was having, there was not as much communication going between the department and the regulated community. And so some of the problems that the department had, and you can correct me if I'm wrong here, were corrected as far as the way that applications came in and then they were communicated back. So the onus went back into the regulated community, in my opinion, that if they changed their application, it would require more work on behalf of the department, as opposed to the department just saying your application is not acceptable. And so the way I read it is that this new provision puts the onus on there that if you're going to change your application as a regulated community, then you're going to have to pay for it. And I think the department many years ago shifted their position so that they would be more efficient. I hope that made sense, Chairman.
That's my recollection too, Member Curry. All right, so I was going to suggest at this point, if the board is agreeable, that we look through the New Mexico Mining Association's Exhibit 7 and Exhibit 8, which is their markup of the department's rule. Now, it was based on an earlier version of the rules. We know some of those things no longer apply, but I think it is helpful to look at it to consider some of the changes they're proposing and have a discussion around those particular changes. Does that sound agreeable? Okay, so let's go to Exhibit 7. Give me a second. I'm going to pull it up electronically so I have it in color. So Exhibit 7 is their proposed markup, Part 71, which is the operating permit. And their first suggested changes is under definitions. It's 20.2.71.7C, and that's under the definition of fee pollutant. They are suggesting to replace total suspended particulates and remove PM10 and PM2.5. And I think in our previous discussion, we decided that particulate matter should be a fee pollutant, and total suspended particulates can't really be a fee pollutant because that rule was rescinded in 2018. So I believe the board supports leaving PM10 and PM2.5 in as a fee pollutant. Is that correct?
That's correct.
So I see a thumbs up from Member Bitzer. Member Curry, thumbs up. Thank you. Okay. So the next item is under 71.111. Oh, wait. Yeah, 0.111. And that is under fee determination. And that again is related to PM10 and PM2.5. And since we decided previously that PM10 and PM2.5, one or the other, should be a fee pollutant, I think we need to reject this paragraph. Does the board agree? Thumbs up, Member Bitzer and Member Curry. Okay. The next item is number 9 under that same paragraph, 71.111. And as we discussed during the hearing, they retracted the need to strike that because it was really just not being stricken from the rule, but being moved in the rule. So I think just for practical reasons, we keep that paragraph as written in the department's rule and reject their proposal here to strike paragraph 9. Is that your understanding, board members?
Yes, I agree. We should keep it.
Member Bitzer, Member Curry, thumbs up on that? Okay. We next proposed change by New Mexico Mining Association in Part 71, 112 emissions fee. It states the fee for each fee pollutant shall be, and they're proposing to leave it at $20 instead of increasing it to $85 per ton. And again, we know it's closer to $40.50 based on the adjustments. Does that, I think our previous discussion would suggest that we don't support this change, and I just want to make sure you're okay with leaving it at $85 a ton. I see some heads nodding in the room, and on the platform, I see Member Bitzer. Member Curry, are you there? Thumbs up. Okay. So we'll leave that at $85 a ton. And so, based on that discussion, I think the added language at the end of 112 paragraph A, we would not accept then either. It's to be consistent. I see the heads nodding in the room. Member Bitzer, Member Curry, do you agree with that? I see heads nodding. Member Bitzer, Member Curry, yes. Okay. And then going down to paragraph D, again, they're going back to the old language for that first change in that paragraph. It says, the department says beginning in 2028, the fees will be subject to the consumer price index. The New Mexico Mining Association is proposing to keep that at or move it to 2009 or keep it at 2009. And I think we rejected that based on our previous discussion. I see heads nodding here. Member Bitzer with a thumbs up. Member Curry? How do you feel about thumbs up? Okay, great. Now we haven't discussed this last change, the second change in paragraph D. And the New Mexico Mining Association, as well as NMOGA, is proposing that no increase in the fee shall take effect until the department presents the review to the board required by section 114 of this rule. And that is the annual review, meaning they come to the department, or excuse me, they come to the board on an annual basis to inform us about how the fees are being managed. I'd like to open discussion on that particular addition.
I don't feel that the fee increase should be tied to the review. I would reject that addition.
Other board members? I think part of the discussion we had on that was the CPI is meant to just keep up with inflation, that it shouldn't, and it should just be automatic, and it should not be contingent on coming to the board. So the question about, will the board be available, and what, will the timing work for the department in order to get that CPI? So at least that was part of the testimony that I heard. Member Bitzer.
Does present to the board necessitate a actual board meeting, or is it just, is it once it's sent through Pam to us that we've been presented? Maybe
Council?
that's a legal question.
Madam Chair and Member Bitzer, yes, board action requires a meeting, which then you'd have to do the whole notice agenda and have a meeting.
So what I'm hearing is that potentially we should reject that new language as proposed by the New Mexico Mining Association. Vice Chair?
Yeah, I agree. I don't think it's needed. As we shared earlier, there's ways for industry to petition the board if there needs to be changes and I think the way that it is currently proposed by the department is, we don't need that language.
I see a thumbs up from member Bitzer, a green, and member Curry. All right, so I think we all agree to not accept that language. In the markup, the next suggested change is under 71.113, and that is to strike paragraph D. I do know that that paragraph has been struck, that the department agreed with the New Mexico Mining Association on that, and so that is not in their current proposal. So I don't know that we have to discuss that. And then their last suggested change is 71.114, and that's annual review. And that would make this rule, Part 71, consistent with Part 75, requiring the department to come before this board to review the operating fees, operating permit program costs annually. And the review shall include information on the budget, expenditures, fund balance, and related projections. The review shall be presented to the board within 6 months following the end of the fiscal year. We had a discussion on this during the hearing. The department is not opposed to adding this for Part 71. I think it's a good change. I wonder what the other board members think.
Thank you. I agree with adding the provision for review.
I see a thumbs up from member Bitzer, member Sweeney, and member Curry. Great. All right. So those are the markups from the New Mexico Mining Association on Part 71. We did have proposed markups from NMOGA as well. It did not come as testimony. We did not have an opportunity to ask questions of NMOGA on that. So for me, I don't give as much weight to that as I do to parties that provided testimony and provided an opportunity for us to cross-examine, for the department to cross-examine and us to ask questions. But I'm just wondering if the board members want to go through NMOGA's markup on Part 71 as well. What's the opinion?
I would agree with you, Chair Ely, for all the reasons you stated.
Do you want to review what they had to say on Part 71?
No.
Other board members? Member Bitzer agrees with you. Thumbs up. Member Curry, thumbs up. Vice Chair Sweeney?
Yeah, I'm fine moving forward without going through the level of detail that we did. But I do just want to say I did read it, and I know that there were, just as part of the due diligence, but I don't think that we need to go through it.
Okay. We did have a discussion on one key point in there, and that they proposed $60 per ton, and we rejected that in our previous discussion. Some of their other changes are aligned with the New Mexico Mining Association, including this annual review. So even if we don't go through the markup, I read it and considered it, and we did have some discussion on it here.
Yes, I just wanted to make sure that that was on the record, that we did look at it. And to your point, Chair, we talked about some specific items in that. And then there was that alignment with the mining association's proposed changes as well.
At this point, I'm going to suggest we move to New Mexico Mining Association Exhibit 8. And that is their proposed changes to Part 75 construction permit fees. And I know their first change, proposed change, is in 75.11, application review fee and annual fee. And the change they are proposing there is to not increase the multiplier and to leave it at 315. As we noted earlier, the current multiplier is not actually 315. Once you look at how it's been adjusted for inflation, it's currently at 539. So you're going from 539 to 585, which is about a 9% increase. Our previous discussion was such that I think the board would agree that we should leave the multiplier as suggested by the department at 585. I just want to confirm that with the board members. Thumbs up from all the board members, right? Their next proposed change is to strike paragraph F in 25.11. Paragraph F has to do with the annual fees, and the department is proposing increasing the annual fees to 2,800, as well as bringing notices of intent in for an annual fee of $700. And I believe our previous discussion is such that we would reject that change, but I want to reconfirm that with the members of the board that are here. And I see a thumbs up from Vice Chair, thumbs up from Member Garcia, thumbs up from Member Bitzer and Member Curry. All right, so we will reject those changes as proposed by the New Mexico Mining Association in 75.11 paragraph F. And then we go down to the next paragraph, paragraph G, which would bring the CPI back to 2005 instead of starting again in 2028. As in operating fees, I think we decided we would reject this because it's not consistent with our other decisions related to the fee increase. I just want to make sure the board is also on board with rejecting this change in paragraph G. Yeah, I see heads nodding, thumbs up. Okay, it's unanimous. And then the very last sentence of paragraph G is similar to the one in construction permits, where they're proposing that no increase in any fee shall take effect until the department delivers the report in 20.2.75.13. Point 13 is the annual review or periodic review. I can't remember what they call it, periodic review. And we rejected it for Title V fees, and I'm going to, so I would suggest that we probably should reject it for construction permit fees. I see thumbs up in the room, thumbs up from Member Bitzer, Member Curry, thumbs up. Okay, great. We'll reject that as well. The next proposed change is in 75.12, and it is again a change that was already removed by the department. The department struck paragraph K. They agreed with the New Mexico Mining Association, so that is no longer in the proposal. So I don't think we really have to discuss that, but accept that that is not going to move. The department will not move forward with that by their own suggestion. Okay. And then there's periodic review, paragraph 13, and they're adding the review shall be presented, and that's a periodic review for the department to come to the board to provide us with an update on the fees. They're adding that the review shall be presented to the board within 6 months following the end of the fiscal year. I believe that's already in the department's proposal as well. Double check. it's already in the department's review, proposal, so I don't think we need to discuss that either. It's just adding, making sure that time frame is there. The end of the fiscal year is July 1. So by the end of the year, every year we will get a review. Okay. So we went through all of the New Mexico Mining Association's markups, considered each of their proposals. And again, NMOGA provided comments, written comments on this. Their major comment that they provided was on the GCP. Major comment, it's different from the Mining Association, was such that the GCPs would only have 20 points for review instead of 30 provided by the department. And I think we've already had a discussion on that and decided that that was not appropriate, that the department made a case for 30 points and that we should stick with 30 points. Do all the board members agree? I see those in the room nodding. Member Curry gives a thumbs up and Member Bitzer. Okay. There's one last point that NMOGA makes, and again, they weren't in the room. We couldn't ask them questions. And this is one I would have liked to ask questions on. And that is in 75.11 paragraph C, and it goes to your point, Member Garcia, regarding assessing points when the department has to do more work on an application when they come back. And what they're suggesting is in exercising this discretion, the department shall consider the nature and scope of the revisions and should not add additional points or fees for changes that require minimal additional review. I agree with the department in their closing arguments that that kind of creates confusion and could set up kind of a contentious discussion between the applicant and the department on when those additional fees should be assessed. So I would suggest we reject that, but I'm open. I'd like to hear from the other board members to see how they feel about that.
Thank you, Chair. I agree that that language would not add any clarity to the rule and maybe even muddy the waters. I would hope that there would be clear communication between the department and the regulated community regarding when there would be additional fees assessed because of changing applications in the process. But I don't think that this language would add any clarity. So I would reject it.
And I just want to say I agree with Member Garcia, and I don't support adding this language.
Member Bitzer, Member Curry. Okay, thumbs up from Member Bitzer, thumbs up from Member Curry. Okay, I think we have gone through the rule and deliberated on each of these points sufficiently, but please let me know if we've missed anything. Is there anything else you'd like to discuss before we close out the deliberations on Part 71 and Part 75? All right. So if there's no further discussion, I would entertain a motion to adopt the proposed changes to NMAD's proposal as discussed, and there's just the one, the annual review, to a motion that would also enable NMAD to work with state archives to format the two rules discussed, as well as enable me to sign a statement of reasons when it is ready. Did I cover all the bases, Council? Okay. So is there a motion for those 3 points?
I'll adopt those 3 points as my motion.
I second.
Great. Pam, could we do a roll call vote on that?
Sorry, I'm trying to get the microphone turned on. Member Bitzer, your vote?
I vote yes.
Okay. Member Curry?
Vote yes.
Chair Ely?
Yes.
Member Garcia?
Yes.
Vice Chair Sweeney?
Yes.
The motion passes.
Congratulations. who've made it through. So at this point, I would like to propose a break before 15-minute break before we go into the hearing on AFFF. One second. Okay, great. We'll see you all back at 10:37. Thank you. Yeah, settled in, and we'll get moving on to the next agenda item. So the next agenda item is in the matter of proposed adoption of 20.4.1 NMAC modifications, exceptions, and omissions related to aqueous film forming foam, and 20.4.3 NMAC hazardous waste fees, and the adoption of 20.13.3 NMAC aqueous film forming foam containing intentionally added PFAS. Before we go into it with the hearing officer, I'd like to make just a brief announcement that Member Garcia has officially resigned from the board and will not be participating in this hearing today. So we'll do another roll call vote to affirm that we have a quorum. Pam?
Member Bitzer, are you with us? Member Bitzer, can you hear us?
I am. Sorry, my screen goes dark. I have to re-log in if I step away for more than 5 minutes. So yeah, I'm here.
Glad to have you. For the record, Member Carrasco, have you joined us? Okay. Member Curry,
I'm here.
Chair Ely,
Present.
Vice Chair Sweeney.
Present.
You have 4 members, and so thus a quorum.
Great, thank you. So Felicia Orth will be the hearing officer on this next item. Madam Hearing Officer, are you ready?
Yes, thank you very much, Madam Chair. Good morning. My name is Felicia Orth, a hearing officer appointed by the Environmental Improvement Board to conduct a hearing in the matter of proposed amendments to 20.4.1 of the New Mexico Administrative Code, 20.4.3 hazardous waste fees, and the adoption of 20.13.3 of the Administrative Code, all relating to aqueous film forming foam and that foam containing intentionally added PFAS. Petitioner was the Resource Protection Division, Hazardous Waste Bureau. Matter was docketed by the administrator as EIB 25-81. We had just one entry of appearance aside from petitioner. That was Mr. Weatherby. Mr. Weatherby, are you online with us?
Yes, I am, Madam Hearing Officer. Can you hear me okay?
Yes, thank you very much.
And I don't anticipate I'll have any questions. I wanted to be able to observe and just in case something came up. But thank you.
Thank you for that, Mr. Weatherby. And in the event you change your mind, it might be best to just reach out through chat and let them know, and I'll call on you.
Will do. Thank you.
Thank you. There was another attempted entry of appearance by National Technology and Engineering Solutions of Sandia. This was an attempt on April 8th. I noted I would be denying that entry of appearance or motion to accept a late entry of appearance. It was just too late, really. However, they helpfully made it clear that what they were interested in was making public comment and asking questions of department witnesses. So I said that that would be allowed. regardless of not accepting their entry of appearance. So that's now on the transcript. Would the department please make their appearances?
Good morning, Madam Hearing Officer, Chair Ely, members of the board. Mark Roseborough on behalf of the New Mexico Environment Department. And with me today is my co-counsel, Gregory Smith-Kier.
Thank you very much. And from your notice of intent, you have several witnesses in support of the petition. Would you comment, please, before I go to any opening statement you'd like to make about how you would intend to present them?
Our witnesses will be presented individually. We will follow the list, the way they are listed in our notice of intent, with one exception. We intend to call Dr. Eric Chapman first, John David Nance second, and from there we'll follow as they're listed in the notice of intent.
All right, thank you. That's helpful. The hearing is being conducted pursuant to the board's rulemaking rules. These are set out in 20.1.1 of the New Mexico Administrative Code. The hearing is being transcribed by David Lee, Umbre reporting. I believe we have sign language interpretation this morning. You can see it there on the screen. Testimony is taken under oath under the board's rules and subject to questioning following that. I will also invite non-technical public comment. Mr. Roseberg, would you like to offer an opening statement, or are there any other preliminary matters to address here? Thank you. Go ahead.
Good morning again, Madam Hearing Officer, Chair Ely, and members of the board. My name is Mark Roseborough, and I'm an Assistant General Counsel at the New Mexico Environment Department. As noted, I'm here today with my co-counsel, Gregory Smith-Kier, John David Nance, the Bureau Chief of the Hazardous Waste Bureau, and a number of our technical witnesses who you'll be hearing from during this hearing. I am here today on behalf of the Hazardous Waste Bureau of the New Mexico Environment Department to present its testimony in support of its proposed amendments to Part 20.4.1 and 20.4.3 of the New Mexico Administrative Code. Additionally, I'm here on behalf of the department to present its testimony in support of proposed new rule 20.13.3 NMAC. Before the board in this matter are three distinct rulemaking actions which I will address this morning. First, I will address the department's proposed new rule at 20.13.3 NMAC. The petition to adopt a new rule at 20.13.3 NMAC derives from the Per and Polyfluoroalkyl Substances Protection Act, which I will refer to as the PFAS Protection Act. The PFAS Protection Act was passed by the New Mexico legislature and signed into law by the governor on April 8, 2025. The proposed new rules at 20.13.3 NMAC address the use of aqueous film-forming foam, which I will refer to as AFFF.
Keep it slow, Mr. Roseberg.
Yes, Madam Hearing Officer. As pertaining to AFFF, the PFAS Protection Act mandated that the Environmental Improvement Board implement three specific categories of rules. First, the PFAS Protection Act requires that the board shall implement rules which require a periodic inventory of AFFF quantities stored or used in New Mexico. Second, the PFAS Protection Act requires that the board shall implement rules which require the use of AFFF for emergency purposes only. Third, the PFAS Protection Act requires that the board shall implement rules which require the cleanup of discarded AFFF pursuant to the New Mexico Hazardous Waste Act. In accordance with the legislature's mandate in the PFAS Protection Act, the department has submitted a rule satisfying those requirements. In support of the proposed new rule at 20.13.3, the department will present technical testimony. It will begin by presenting the technical testimony of Dr. Eric Chapman. Dr. Chapman will present on the science of PFAS generally and AFFF specifically, including the processes by which it moves through the environment and affects the health of humans and the environment, including the occupational health effects of those who use AFFF in the course of their work. His testimony will also address some of the well-known instances of PFAS contamination in New Mexico. Dr. Chapman's testimony is also informative of the proposed amendments to 20.4.1 NMAC that relate to AFFF and should be understood to be in support of any portion of the department's proposed regulatory changes which address AFFF. Following Dr. Chapman, the department will present the technical testimony of John David Nance, Bureau Chief of the Hazardous Waste Bureau of the New Mexico Environment Department. Mr. Nance will present testimony as to the public notice and engagement efforts of the department in relation to the proposed regulatory changes in this matter. Mr. Nance will also describe the legal grounding for the main provisions of the proposed new rule 20.13.3 NMAC, addressing their importance in the overall scheme of regulating AFFF. Mr. Nance will also present testimony in support of the proposed amendments to 20.4.1 NMAC, addressing the importance of regulating AFFF as a hazardous waste and the necessity of New Mexico having a federally authorized state-run hazardous waste program. I'll discuss those changes in a bit. Following Mr. Nance, the department will present the testimony of Andrew Hautzinger, Special Project Coordinator for the department's hazardous waste, or the department's Water Protection Division. Mr. Hautzinger's testimony is offered in support of new rule 20.13.3 NMAC and the amendments to 20.4.1 NMAC pertaining to the regulation of AFFF. Mr. Hautzinger's testimony will address well-known instances of PFAS contamination in New Mexico, known impacts to New Mexico's drinking water caused by PFAS, the efforts to remediate PFAS contamination in New Mexico, including the department's financial costs and administrative efforts. Finally, Mr. Hautzinger will address some of the broader economic costs suffered by New Mexicans related to PFAS contamination. Following Mr. Hautzinger, the department will present the technical testimony of Dr. Kyle Stacks, Bureau Chief of the department's Resource Protection, Compliance, and Enforcement Bureau. Dr. Staggs will provide testimony related to the compliance and enforcement processes and provisions in proposed new rule 20.13.3 NMAC. Following the testimony of Dr. Staggs, the department will present evidence supporting its proposed amendments. In addition, its proposed amendments to 20.4.1, in addition to the testimony which had already been offered by Dr. Chapman, Mr. Nance, and Mr. Hautzinger. The department seeks to amend 20.4.1 NMAC for two reasons: to comply with the recent legislative amendments to the New Mexico Hazardous Waste Act, and to make changes necessary to support the federal reauthorization of New Mexico's hazardous waste regulations. On April 8, 2025, the New Mexico legislature passed House Bill 140, which was signed into law by the governor. House Bill 140 amended the Hazardous Waste Act by including discarded AFFF containing intentionally added PFAS in the definition of hazardous waste. Legislative change, I'll note, that was ignored by many of the public commenters who said the board does not have the authority to take the actions we're requesting to take today. House Bill 140 further amended the Hazardous Waste Act to give this board the power to adopt rules under the Hazardous Waste Act pertaining to AFFF containing intentionally added PFAS. The department seeks to amend 20.4.1 to make its regulations consistent with House Bill 140's statutory revisions to the Hazardous Waste Act. In support of the proposed amendments to implement HB 140, the department will call Dr. Ranjana Dangi, a senior environmental scientist with the department. Dr. Dangi's testimony will be offered in support of the department's amendments to 20.4.1.201 D, E, and F, and 20.4.1.801C. Dr. Dongi will describe why the department chose each of the 22 PFAS chemicals included in the department's revisions and will address the known toxicity associated with each chemical. Her testimony will demonstrate that the department's revisions to 20.4.1 NMAC are data-driven and risk-based. Following Dr. Dongi's testimony, the department will call Janosch Walters, an energy and environmental engineering consultant with the Eastern Research Group. Mr. Walters will testify in support of the department's revisions to 20.4.1.801C. His testimony will address the treatment standards and technologies selected by the department, showing that the department's proposed revisions give AFFF generators options based in technological reality while providing top-end remediation outcomes in instances where AFFF must be deployed in emergencies. The remainder of the amendments to 20.4.1 NMAC are necessary to support the department's efforts to obtain federal reauthorization of its hazardous waste program and regulation. Hazardous wastes are federally regulated by the Resource Conservation and Recovery Act. States may obtain federal authorization to administer state hazardous waste programs by complying with the requirements outlined in 40 CFR Part 271. The requirements outlined in 40 CFR Part 271. You're welcome. Since 1985, New Mexico has administered its own hazardous waste program pursuant to the authorization authority granted by the United States Environmental Protection Agency. Under the Hazardous Waste Act, the New Mexico legislature mandated that this board shall adopt rules for the management of hazardous waste as may be necessary to protect the public health and the environment that are equivalent to and at least as stringent as federal regulations adopted by the EPA pursuant to the Resource Conservation and Recovery Act. It is this authority and mandate of the board that the department invokes in its proposed reauthorization amendments, which are necessary for federal reauthorization of the department's hazardous waste program. In support of its reauthorization amendments to 20.4.1 NMAC, the department will call Aaron Kaufman. Mr. Kaufman's testimony will provide a high-level understanding of the reauthorization process, a description of the amendments proposed, and a description of the department's coordination with the U.S. Environmental Protection Agency in developing the amendments before the board today. Finally, the department seeks to amend 20.4.3 NMAC to correct a typographical error in the existing language. As currently drafted, the fee language in 20.4.3.202C refers readers to 20.4.3.401 NMAC. The department seeks to revise this provision to refer readers to 20.4.3.201, which is the intended reference provision. In support of its proposed amendments to 20.4.3 NMAC, the department will call Aaron Kaufman to describe the rationale and necessity for the amendment proposed. A little more than a year ago today, House Bills 212, the PFAS Protection Act, and House Bill 140 were signed into law. Taken together, these laws represent a deep commitment to protecting New Mexico's people and environment from harmful and dangerous PFAS. In the year since these landmark laws were enacted, the department has worked tirelessly to implement these rules, realizing that time is of the essence. I wholeheartedly encourage the board to adopt the proposed regulatory changes proposed by the department. Thank you.
Thank you very much, Mr. Roseborough. I believe we just go directly into your witnesses. I don't think we have other preliminary matters here.
If Mr. Weatherby doesn't.
He would not. Thank you.
Mr. Smith here is going to handle our first two witnesses.
Terrific. Thank you. Let's see, Dr. Chapman, it might be easiest for you to take one of the ends of the dais so you can make eye contact with Mr. Smith Care easily.
And I need to share a PowerPoint. Luis, can you give me authority to do that? Yeah. No.
Dr. Chapman, would you spell your first and last name, please?
Yes, good morning, Madam Hearing Officer, members of the board. My name is Eric J. Chapman, C-H-A-P-M-A-N.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Smith here.
Thank you, Madam Hearing Officer, Madam Chair, members of the board. Dr. Chapman, will you please state and spell your name for the record?
Yes, my name is Eric J. Chapman, C-H-A-P-M-A-N.
And where are you?
The New Mexico Environment Department.
How long have you been employed there and what is your current position?
Since August of 2025, I serve as the Chief Science Coordinator for the department.
And can you briefly discuss for us your education and professional qualifications?
Sure. I have a PhD and Master's in Environmental Science from Arizona State University. I am formally trained in biogeochemistry, geochemistry, a subdiscipline of environmental science focused on understanding how materials cycle within living and non-living elements in the environment. I also hold a bachelor's in genetics and cell biology and a minor in chemistry from the University of Minnesota. Prior to my work for the department, from 2019 to 2025, I was a biology professor at the University of St. Thomas, a large undergraduate institution in Minnesota. I taught over 1,000 students introductory and upper-level biology courses on human impacts on the environment with a focus on chemicals of emerging concern, including PFAS.
Did you file written testimony in this matter?
I did.
Do you have any corrections that you'd like to make to your written testimony?
No.
Do you adopt that written testimony as your testimony here today?
Yes.
Will you please provide us a summary of your written testimony?
Sure. I present this testimony on behalf of the department in support of the department's petition and proposed rules. My testimony will provide an overview of the science of PFAS, aqueous film forming foam, or AFFF, general movement of AFFF in the environment, and AFFF contamination on military bases and surrounding environments in New Mexico. PFAS contamination in New Mexico can be categorized in two distinct bins. In one bin are hotspots from AFFF use on and near military bases. The other bin is low-level and extensive contamination from consumer products. My testimony will show that once released into the environment, PFAS contamination from AFFF becomes widespread, creating a multitude of indirect exposure pathways that are difficult to remediate. I will end with a call for adopting the proposed rule to reduce direct and indirect exposure to PFAS.
Can you please provide some context for New Mexico's actions to regulate PFAS?
Sure. One of the many catalysts for states' actions regulating PFAS is the bioaccumulative, persistent, and toxic nature of many PFAS. Another catalyst is the extent of PFAS contamination in New Mexico today. In response, in the 2025 legislative session, New Mexico legislators passed and Governor Lujan Grisham signed into law 2 bills focused on reducing PFAS use and disposal. First, the PFAS Protection Act outlines prohibitions of consumer products containing PFAS. In fact, just last month, this very board voted to adopt a landmark rule to implement the act, which requires manufacturers to label consumer products containing PFAS. Second, the PFAS firefighting foam bill that is the subject of this rulemaking is in response to the extent of PFAS contamination from AFFF. New Mexico is home to numerous important military bases that help to enhance national security, provide livelihoods for hardworking New Mexicans, and serve as economic engines in various reaches of the state. Unfortunately, military bases have also been linked with extensive contamination from AFFF, from fire suppression training, and emergency response operations. Because of the contamination, New Mexico is involved with complex and expensive litigation around Cannon Air Force Base in Curry County and Holloman Air Force Base in Otero County. Further, recent peer-reviewed research by scientists at the University of New Mexico has documented the highest concentrations ever observed globally in plant and animal tissues at Holloman Lake near Holloman Air Force Base, which neighbors White Sands National Park and receives 700,000 annual visitors.
Can you tell us broadly about the PFAS family and how their properties influence their behavior in the environment?
PFAS are persistent, mobile, and many have been shown to be bioaccumulative and toxic to human health and wildlife. PFAS make up a large family of 14,000 chemicals that vary structurally, which can influence the biological, chemical, and physical properties when released into the environment. The family contains both non-polymer and polymer PFAS. Both non-polymer and polymer PFAS. Within classes, there are many subclasses, which include per and polyfluoroalkyl substances, fluoropolymers, and side chain fluorinated polymers. Much attention has focused on the group of PFAA because of well-established detrimental effects of legacy substances such as PFOA and PFOS. Legacy PFAS are in water, soils, and in biological samples, including human tissue, fish, and other foods. Concerns about legacy PFAS led to a newer class of alternatives, though there are emerging concerns of this new class. Some alternatives, such as PFNA, show higher toxicity across developmental stages in zebrafish and can accumulate in plants and animals in food webs. These alternatives illustrate shared concern across all PFAS.
Can you please describe how PFAS chain influences transport through the environment?
Chain length refers to the number of carbons and affects the movement in the environment. Long chain are suspended in particulate matter or in sediments, whereas short chain tend to be in the water column. Long chain can also aggregate on clay particles in soil and increase retention. Long chain PFOS and PFOA are decreasing in human samples, but increasing in sediments. Short chain are highly mobile in both soil and water and rapidly contaminate drinking water sources, are uptaken by edible portions of plants, and can bioaccumulate along the food web. Short chain migrate through the soil column at faster rates compared with long chain PFAS, increasing groundwater contamination risks. To make matters worse, treatment removal technologies are less effective at removing short chain PFAS compared to long chain, highlighting concerns with short chain replacements.
Can you provide a general overview of aqueous film forming foam?
AFFF is a surfactant solution that contains PFAS. Since its introduction in the 1960s, AFFF had been used extensively in the United States in hydrocarbon fire or Class B fire suppression. Class A foams are used on wood fuel fires and do not contain PFAS. As a response to concerns about PFAS containing firefighting foams, fluorine-free foams, or F3, which do not contain PFAS, have become the global standard for Class B firefighting. AFFF has three primary properties that are useful in fire extinguishing. One is the formation of aqueous film that spreads over fuels and suppresses oxygen. Two, it creates a foam blanket to smother fire and prevent further ignition. And three, it cools fuel with high water content. Generally speaking, AFFF formulations contain solvents, hydrocarbon surfactants, fluorosurfactants, polymers, and additives, and AFFF concentrates are available in 1, 3, and 6 percentages. Historically, AFFF was manufactured in two ways, through telomerization and electrochemical fluorination, or ECF. AFFF manufactured through ECF creates long-chain PFAAs, and telomerization creates polyfluorinated fluorotelomeres. Both manufacturing processes create diverse formulations that produce PFOS and, to a lesser extent, PFCAs of various chain length. Following 3M's phase out of PFOS, AFFF is no longer produced via ECF. Fluorotelomere-based formulations contain many PFAA precursors that can readily undergo biotransformation into terminal PFAS. Further, legacy stocks of older formulations of AFFF remain and are sources of PFAA in the environment.
Can you provide a general overview of AFFF use and statistics?
AFFF is used entirely by military, aviation, municipal fire departments, petroleum refineries, and petrochemical manufacturing. The military represents the highest percentage use of all sectors at 29%, followed by petrochemical manufacturing and petroleum refineries at 21% and 20% respectively. The 2020 National Defense Authorization Act required the Department of Defense to phase out the use of AFFF by October 2024. However, waivers pushing the deadline to October 2026 have allowed for continued use.
What are the impacts of occupational use of AFFF on human health?
Firefighters and military service members are occupationally exposed to PFAS through AFFF use. This increases PFAS concentration in human serum, which contributes to elevated risks of certain cancers. Review studies report elevated cancer risks for firefighters for bladder, brain, colorectal, non-Hodgkin's lymphoma, skin melanoma, prostate, and testicular cancer. Other review studies have found significant increases in rectal, prostate, bladder, testicular cancer, and mesothelioma and malignant melanoma in firefighters. Military service members also have elevated risks of certain cancers. For instance, Purdue et al. In 2023 found that elevated PFOS serum concentrations were associated with testicular cancer, highlighting how occupational exposure to AFFF increases the risk of various cancers.
Can you describe AFFF environmental contamination from a life cycle perspective?
Firefighting foam is manufactured into AFFF concentrate from chemical inputs, stored as concentrate, and used in fixed facilities or on truck where it is used in training or fire suppression activities or accidentally spilled. Whether used in training or accidental spills, foam discharge may be contained or uncontained. Contained foam may be collected for disposal or treated either through incineration or landfilling or released into sanitary sewers. Uncontained foam may be released into sanitary sewers, storm sewers, surface water, or groundwater. Foam released into sanitary sewers ultimately enter wastewater treatment plants and can be discharged into the environment even when contained, creating contamination in the air, water, and soil. Researchers have documented how off-site migration of AFFF can pose significant human and environmental health risks in aquatic systems from fish consumption and groundwater use. As a testament to the persistence of PFAS, researchers have found high levels of contamination at airports despite AFFF not being used for decades. AFFF can contain several types of precursors that can be transformed into terminal PFAS, illustrating how AFFF released into the environment can serve as a source of contamination long after its use. A recent study estimated that precursors in AFFF account for around 25% of total PFAS in groundwater and aquifer solid samples. This finding is significant because it suggests that precursors at contaminated sites can continue to generate a significant amount of additional contamination in groundwater following remediation.
Can you briefly summarize how PFAS enter the environment?
PFAS enters the environment in both direct and indirect manners and can enter solid waste or aqueous waste streams along the production to disposal pipeline. Direct sources include industrial primary manufacturing operations, metal plating operations, through AFFF use, and from consumer products. Indirect sources of PFAS include landfill leachate, wastewater treatment plants, and from land-applied biosolids. Once released into the environment, PFAS move through the air, in dust, and as aerosols through rain, surface, and groundwater. These transport mechanisms represent potential exposure opportunities that contribute to human health effects. Studies in the literature suggest that AFFF use sites are associated with the highest concentration of legacy PFAS in groundwater and are potential sources of precursors that may transform into persistent PFAS. The transformation of precursors indicates that AFFF sites may be long-term sources of terminal PFAS contamination.
Can you provide a little context about Cannon Air Force Base and describe what is known about PFAS contamination?
Cannon Air Force Base was built in 1942 and is located 7 miles southwest of Clovis in Curry County. PFAS contamination at Cannon is well characterized scientifically, the subject of law review articles, and publicized in the popular press. PFAS contamination was first documented in 2015, and AFFF use occurred at 2 primary locations from the 1970s until 2011, leading to PFAS in monitoring wells exceeding national drinking water standards at the east side of the base, near former sewage lagoons, and the southeast corner near fire training areas. Results from monitoring wells at Cannon indicate variable rates at which PFAS move through soil toward groundwater, variation in different types of PFAS across Cannon, high proportions of short-chain PFAS in the east wells, and high proportion of long-chain in the southeastern corner of the base. Total discharge rates into groundwater vary 5 orders of magnitude and can be as high as 10 grams of PFAS per day.
Can you provide a little context about Holloman Air Force Base and describe what is known about PFAS contamination at Holloman?
Holloman Air Force Base was established in 1942 and is located 6 miles southwest of Alamogordo in Otero County. Holloman Lake receives effluent from the base as an artificial wastewater and stormwater catchment system that was built in the 1960s. Despite receiving waste, Holloman Lake provides aquatic habitat in the semi-arid Chihuahuan Desert. Though, decades of effluent from the base containing runoff from AFFF contaminated soil, water, plants, and wildlife. Researchers from UNM have quantified PFAS concentrations in the food web around Holloman Lake. They quantified PFAS concentrations in birds and small mammals, and they found record high levels of PFAS in muscle and liver tissues in birds. This figure shows bird muscle and liver median PFAS concentrations at Holloman in orange compared with off-site control sites in gray. PFOS concentrations in both muscle and liver approached 10,000 nanograms per gram, and all of Holloman's sampling locations had significantly higher concentrations of PFAS compared to control sites. In another study, the same team found record high levels of PFAS contamination in abiotic and biotic samples. This figure shows sampling locations in panel A, water concentrations of various PFAS at sample location in panel B, and the proportion of PFAS type at each sample location in panel C. They measured water concentrations of PFAS at 4 locations at Holloman Lake: the North Outfall, which receives effluent from the base, North Lake, East Outfall, and South Lake. Concentrations in Holloman Lake water were measured as high as 10,000 nanograms per liter, or 2,500 times the EPA drinking water standard for PFOS. With respect to soil, researchers sampled shoreline, nearshore, uplands, wetlands, and ghost wetland locations shown in panel A. They found concentrations of PFOS in shoreline soils in panel D to be above the median concentration of PFOS found in soils near military installations throughout the world. Further, researchers found the proportion of PFOS type varied by sampling location, with high proportions of PFOS in shoreline soils and PFPEA in wetland soils shown in panel C. The team expanded upon their previous study and measured concentrations of PFOS in plants, birds, and mammals throughout the food web. This figure shows proportion and concentration of PFOS types in the Holloman Lake ecosystem. They found the highest levels of PFOS ever recorded in wildlife, which was greater than 120,000 nanograms per gram in Merriam's kangaroo rat, and elevated levels of PFOS in various birds and the Chihuahuan pocket mouse. The overwhelming proportion of PFOS found at Holloman was PFOS, an indication that PFOS bioaccumulates in higher trophic levels.
Can you please put the concentrations observed at Cannon and Holloman into a broader context?
This table shows observed PFOS ranges in animal liver tissue, context and regulatory importance, and references. Below 5 nanograms of PFOS per gram of tissue are typical non-impacted levels found in wildlife surveys. Between 5 and 50 are found in urban areas, and in some locations trigger increased monitoring and narrow consumption advisories for fish. In Michigan, PFOS in animal tissues between 50 and 500 nanograms per gram trigger do not eat advisories for fish and game. Between 500 and 5,000 are point source hotspots such as fire training pits or chemical plants. Above 100,000 levels are amongst the highest levels recorded in the world, found right here in New Mexico. The department has collected PFOS concentration data from groundwater monitoring wells and surface water locations at Holloman. This table highlights groundwater select PFOS concentrations from a few PFOS and total PFOS summed across the suite of analytes. The table also compares the total PFOS at each sampling location to the EPA drinking water standard. For instance, at the evaporation pond number 2, groundwater PFOS was over 1 million nanograms per liter. Total was over 1.5 nanograms per liter, which is nearly 400,000 times the EPA drinking water limit for PFOS. Similarly, the department has conducted extensive surface water sampling at Holloman. Across 7 sampling locations, PFOS ranged from nearly 1,000 to over 2,000 nanograms per liter, and total PFOS ranged from low thousands to over 100,000 nanograms per liter or greater than 25,000 times the EPA drinking water standard. AFFF use at Holloman reaches Holloman Lake, which affects surface water, groundwater, and plants and animals throughout the system. High levels of contamination prompted the New Mexico Department of Health to issue consumption advisories for fish and game for Holloman Lake in 2025. Officials closed public access to the lake in August of 2025, and the department conducted a survey to investigate visitation and potential exposure in October 2025, with a final report pending.
Can you end with a summary of the importance of addressing PFOS contamination from AFFF use?
AFFF has been used on military installations and in firefighting operations to extinguish Class B hydrocarbon fires since the 1970s. Contamination is found on military installations and in adjacent ecosystems, highlighting the damage caused by unregulated use of AFFF in training and emergency operations. Long-term use has contaminated surface water, groundwater, soil, and plants and animals. Given the persistence of PFOS, contamination from AFFF can linger for decades, even after its use is phased out. Additionally, AFFF use sites can be sources of terminal PFAS long after AFFF is no longer used, complicating cleanup and remediation efforts. Further, AFFF use is in various stages of phase out, but considerable stockpiles of AFFF exist, leading to potential environmental discharge. In the 2025 legislative session, our state leaders took bold action to protect New Mexicans from PFAS in two ways. First, the PFAS Protection Act became law, and this board recently adopted a final rule to implement the act, which protects New Mexicans and our environment from PFAS in consumer products. Second, the firefighting foam bill defined discarded AFFF containing PFAS as hazardous waste, ensuring oversight in how AFFF is managed, stored, used, and disposed of on military bases and other facilities. The combination of these actions confronts the environmental and human health effects of PFAS. We can turn the tide on costly and diffuse downstream PFAS contamination, ultimately reducing exposure pathways to humans. I respectfully encourage the board to adopt the proposed rules.
Thank you, Dr. Chapman. Madam Hearing Officer, Dr. Chapman is now available for questions.
Thank you very much. Dr. Chapman, Mr. Smith-Care. Are there questions of Dr. Chapman before I turn to the board? Sir, if you need to come to a microphone. And turn it green.
Dr. Chapman, my name is Konstantin Parhomenko. I represent Sandia National Laboratories, and we perform research into AFFF and controlled laboratory conditions. So I will ask you some questions about your testimony. That's okay. Dr. Chapman, your testimony describes how PFAS from AFFF contaminates soil and groundwater, correct?
That's correct.
And you testified that PFAS are highly mobile in the environment, right?
Yes, they can be.
You testified that once PFAS enter the soil and vadose zone, they create persistent contaminated soil and vadose zone. They create persistent contamination pools, right?
PFAS is a persistent chemical, yeah.
And the contamination you described resulted from large volume releases of AFFF into the environment, right?
How do you find large volumes?
Hundreds and maybe even thousands of gallons at a time, depending on whatever the firefighting exercise or activity was taking place.
I don't think my testimony contemplates the volume of release.
But it would be not a small amount, right? It would a release of, let's say, 10 milliliters would not trigger the kind of problem your testimony contemplates, correct?
That was not the subject of my testimony.
All right, I'll move on. Dr. Chapman, you are, of course, familiar with how chemical laboratories operate, right?
How chemical laboratories what?
Operate. Objection, that's not the scope of this test.
Yeah.
You've seen the inside of several laboratories, it's fair to say.
Yeah, I'm not sure how this relates to my testimony.
So, Mr. Parhomenko, obviously your questions need to relate to the subject of Dr. Chapman's testimony.
Of course. So my point is, Dr. Chapman, if we imagine a controlled environment in a laboratory where actually the quantities of AFFF we work with and research are very limited, and it's not actually released into the environment, but any waste product is treated as hazardous waste and safely disposed of. Under that situation, there would not be actually any environmental release pathway, correct? Objection, outside the scope of this test.
Dr. Chapman, if this is sufficiently close to your testimony that you'd like to answer it, go ahead. If it is not, and there's one of the department's other six witnesses is better to answer it, please just identify that witness.
Thank you. Yeah, research use of AFFF was not in the scope of my testimony.
But my point is, Dr. Chapman, if there is no release into the environment, there is no problem. Is that a fair assessment?
Mr. Parkamenko, he's given you his answer. I'll ask you to direct your questions to someone else. For example, Mr. Nance may be able to answer your question about how this regulation will be applied.
All right, I'll move on. Dr. Chapman, you also testified about the properties of AFFF, correct?
I spoke to how there are chemical properties of AFFF that lead to persistence, but it was very general.
All right. No further questions at this time. Thank you.
All right, thank you. Anyone else? No, let's turn to the board. Chair Ely, would you like to start?
I'm just curious. Good morning, Dr. Chapman. How did the investigation at Holloman and Cannon get started? What prompted people to start looking closely at PFAS there?
Good morning, Chair Ely. I am not up to speed on the investigations and litigation that happened at Cannon and Holloman. I suggest perhaps talking to, I'm not 100% sure, but Mr. Nance, I think, can speak more clearly to that topic.
That's fine. Thank you.
All right, Vice Chair Sweeney.
I don't have any questions at this time.
All right, thank you. On the platform, Member Curry, do you have a question? All right, I saw you. Thank you. Member Bitzer, do you have a question?
Maybe this is outside the scope. I'll just park the question for anybody down the line if somebody wants to come on and this current witness isn't the right guy. But I met a guy a year and a half or so ago who had to put down 4,000 head of dairy cattle because he's downstream from Holloman. Everyone's admitting guilt, but there wasn't a settlement in the case. Do we know if that case is still pending? Just putting that out there. It's just a huge tragedy for that part of the state and for this guy's business and his livelihood. So anyway, just throwing that out. If anybody knows, let me know.
I would suggest Mr. Nance maybe.
All right, Mr. Smith here just said that Mr. Nance is probably the best witness to ask that question. Member Bitzer.
Thank you.
Thank you. Any other questions from the board or its council? Council.
Thank you, Madam Hearing Officer. So Dr. Chapman, you mentioned that there is, I can't remember your words, but a lot of this product that's exists. I can't, you said something like a lot of it has already been made and warehoused, just AFFF.
I mentioned that there are stockpiles of
Right,
AFFF,
right,
yes.
right. And do we know how much? Because I think you said something like there's a large or huge stockpile of it.
I think there have been inventories, but I think they're a little out of date now. They were made, the ones that I've seen are maybe a couple of decades old.
All right, so but if it's not being used, then until someone destroys it or whatever, it's going to exist.
Yes.
Okay.
Yeah.
So is that, I don't know if that's contemplated. I mean, because that it seems based on your testimony that it's got to be disposed of in an appropriate way, but there's this huge stockpile, or stockpiles. That's got to be a big concern.
Yeah, and I think Mr. Nance can speak to
Okay.
the maybe volumes that are in the state outside of my testimony, but I have heard about other states having buyback programs to sort of like more effectively manage the stockpiles that do exist.
Okay. All right. Thank you. That's it. Thank you.
Okay. Mr. Smith-Kerr, anything further?
I have nothing.
All right. Thank you very much, Dr. Chapman.
Thank you.
Officer, I do need to admit the exhibits that are attached to this testimony.
All right. Do I hear any objections to the admission of Dr. Chapman's exhibits? No. Thank you very much. They're admitted. Mr. Smith-Kerr, we have about 25 minutes before we take a lunch break. Could we take the first chunk of Mr. Nance's testimony? Sorry. Okay.
We now call John David Nance. Just a second to share my screen.
Mr. Nance, would you spell your first and last name, please?
Yes, first name John David, JOHN DAVID. Last name Nance, NANCE.
Do you swear or affirm to tell the truth?
Yes.
Thank you very much. Go ahead, Mr. Smith-Kerr.
Mr. Nance, where are you employed?
I am employed at the New Mexico Environment Department.
And how long have you been employed there, and what is your current position?
Employed for 2 years. I am the Hazardous Waste Bureau Chief.
Can you briefly describe your education and professional qualifications?
Yes, I have a bachelor's in Earth and Planetary Sciences, essentially a geology degree. I have 21 years experience in the environmental field, 15 of which was in environmental consulting, both under RIPRA and CERCLA.
Thank you. Did you file direct written testimony in this matter?
Yes.
Do you have any corrections that you'd like to make to that written testimony?
No.
Do you adopt that written testimony as your testimony here today?
Yes.
Can you please provide a summary of your written testimony?
Yes. Madam Chair, members of the board, today I'm going to provide an overview of what House Bill 140 accomplished, as well as discuss the AFFF provisions in House Bill 212. I'll then also talk about the importance of regulating AFFF or PFAS containing AFFF. Also the importance of our RCRA program reauthorization, and also reasons for stop using PFAS containing AFFF in practice. Slide. First and foremost, sure. First and foremost, NMAD performed all the legal and required public notice actions for leading up to this hearing. That did include posting to the New Mexico Register, also posting in a general circulation newspaper, as well as having public comment through our smart comment portal, and also engagement with nations, tribes, and pueblos. With that, we have received comments as has been stated previously. Next slide. Moving on to House Bill 140. House Bill 140 amended Section 74.4.3 of the Hazardous Waste Act to include discarded AFFF intentionally containing PFAS to the definition of a hazardous waste. With that, the legislature body qualified these chemicals as a hazardous waste at the state level. In practice, House Bill 140 allows New Mexico to treat PFAS containing AFFF, discarded PFAS containing AFFF, in the same cradle to grave regulatory rigor that other hazardous wastes are treated as. This also allows us to maintain that oversight, regardless of how the federal government treats and considers PFAS. House Bill 140 also gives the authority to the Environmental Improvement Board, this board, to adopt rules pertaining to discarded PFAS-containing AFFF. It also has a key technical provision in House Bill 140, which freezes the list of federally recognized hazardous waste as of July 1, 2025. This allows New Mexico to maintain the rigor that we have been working with, regardless if the federal government decides to roll back on federally listed hazardous waste. Moving over to House Bill 212, which is also known as the PFAS Protection Act. There are three main requirements that pertain to PFAS containing AFFF in that act. Those requirements require facilities to report stored volumes of PFAS containing AFFF to the state. It also states that those existing volumes can only be used in emergency situations only. And if it is used, those releases must be managed and cleaned up under the hazardous waste regulations. Moving over to the importance of regulating PFAS containing AFFF. Essentially, public interest is served across four key groups. Those include residents and public health, landowners, farmers and ranchers, emergency and first responders, and ultimately to the New Mexico taxpayers themselves. With residents and public health, by reducing use of PFAS containing AFFF to emergency use only, we greatly reduce the release to the environment and the potential impacts to our citizens, to the environment, and also to our wildlife. With landowners, farmers, and ranchers, as Dr. Chapman testified earlier, we have seen the impacts of PFAS releases in areas in our state, specifically in the Clovis area. By regulating AFFF, we can ensure that property remains a viable asset for those property owners, farmers, and ranchers. This will prevent future releases into the environment, maintaining the equity that they have in the land, and also the ability for the land to be viable and produce as we use in our farming and our ranching in our state. With emergency and first responders, our first responders are on the front lines of protecting our citizens when an emergency arises. They are in direct contact with these chemicals, and by reducing the use of PFAS containing AFFF to only emergency response only, we can greatly reduce the exposures that these first responders and emergency responding personnel come in contact with. This will help with with the reduction of prolonged health effects by being in contact. By doing this, we'd be reducing only to emergency use and not using for testing or handling. And last, for our New Mexico taxpayers, by regulating PFAS containing AFFF, we can, at a state level, shift the burden from the taxpayers for response and cleanup and protecting from these releases, and shift that burden onto the responsible parties who are the ones who actually released these chemicals into the environment. Moving over to the importance of reauthorizing the New Mexico State RCRA program. It's the reauthorization of the program is a fundamental necessity. The program is built upon accountability, protection, and economic fairness. With accountability, we as New Mexico can hold private and federal facilities to our New Mexico standards. Without this reauthorization, we will need to rely on federal oversight, which may or may not align with our New Mexico priorities as we have them. For protection of our state, through localized expertise and response, we as New Mexicans understand the complex hydrogeology, geology, and geography that our state contains. It's a very diverse state. With that knowledge, we're able to respond and regulate at a local level that is beneficial for our citizens. Relying on a federal oversight, people who are not in this state, likely from DC, they may not understand those complex challenges that we have in our state. And so allowing for the reauthorization of our state program will allow us as New Mexicans to protect our citizens for New Mexico. And also, as stated previously, the economic fairness is being able to shift financial burdens from New Mexico residents to those responsible parties who initially have released these chemicals into the environment. And last, moving over to the importance for the cessation of using PFAS containing AFFF. Every non-emergency discharge is essentially a preventable environmental exposure. With that, if we're able to stop using PFAS containing AFFF, if there is an emergency that arises or a non-emergency that causes a release, if we're able to eliminate using them, then those chemicals will not be emitted into the environment. So this is essentially taking a proactive approach, not a reactive one, where we respond to an emergency or a release. With that, there are non-fluorinated options that are commercially available, and facilities within the state and nationally have already started that transition over to those non-fluorinated options. With that, the transition from using PFAS containing AFFF to a non-fluorinated option is viable. Also, as Dr. Chapman stated earlier, PFAS is very prevalent in the environment and is a very stable chemical. It does not degrade. With that, it will last for a very long time and causes challenges for cleanup and getting that out of our resources in our environment, or citizens can be potentially exposed. This contamination does not just degrade the environment, but it effectively robs New Mexicans of their right to safely fish, hunt, and recreate on their own public lands. Prohibiting the use of PFAS containing AFFF in non-emergency settings is not just an environmental mandate, it is a common sense measure to prevent the further destruction of New Mexican property and the permanent degradation of our limited water resources. In closing, for the reasons stated in this testimony, I encourage the board to adopt NMAD's proposed rules in this matter.
Thank you, Mr. Nance. And Mr. Nance is now available.
Thank you, Mr. Nance and Mr. Smith here. Are there questions of Mr. Nance?
Yes.
Mr. Parkamenko, come to a microphone.
Mr. Nance, I believe you testified that the purpose of this proposed rule is to protect public health and the environment, correct?
Correct.
And the specific harm the rule is really designed to tackle is the release of these PFAS containing AFFF foams into the environment, right?
Yes.
And so in your testimony, well, I'm sure you're aware of the problems around Cannon Air Force Base and Lake Holloman. You've heard that testimony, right?
Yes.
Are you aware that those releases were really the result of repeated use and release of AFFF at those military installations?
Those
military installations?
Military installations. Those were related to releases of PFAS containing AFFF.
Correct. So you're aware that in each of those cases, the volumes involved were quite large, numbering hundreds of thousands of gallons of AFFF released into the environment. Correct?
Objection, outside the scope, and
Yeah, you should lay a foundation and make sure that Mr. Nance is familiar with the details of those events.
Mr. Nance, have you reviewed any testimony in this case that discussed the extent of the contamination at Lake Holloman and the Cannon Air Force Base?
Yes.
So are you aware of the causes of what resulted in those contaminated sites?
Yes.
And it would be fair to say that the causes were the repeated use of large quantities of AFFF in firefighting activities, including training exercises?
Those were from use of emergency response and for the use of training in firefighting situations.
Thank you. Now, Mr. Nance, are you aware that some entities in New Mexico, such as laboratories, use small quantities of AFFF in strictly controlled laboratory settings for research purposes?
Not until recently.
Well, Mr. Nance, I represent just such an entity. And hypothetically speaking, if there is no release, if you just use a small quantity and then dispose of it as hazardous waste, would you agree that that would not cause harm to the environment?
Well, under the current law that House Bill 212 laid out, by it stating the legislature itself put in law that the use of PFAS containing AFFF can only occur under emergency responses only. So under that law, that would be the only use where that could be done. For this rulemaking, and what we're trying to do is provide rules around that law that New Mexico State Legislature had put in place.
Indeed, Mr. Nance. So my line of questioning concerns the technical legal definition of the word use, which I believe is beyond the scope of your background. You're not a lawyer, are you, Mr. Nance?
No, I'm not.
You don't hold a law degree?
No.
You're not a member of any bar?
No.
You don't have a license to practice law in any state?
objection, asked.
All right, Mr. Perkmeka, what's your further question?
I'll move on. So I guess the point I was making, Mr. Nance, is research is or could be defined as not being used. Now, Mr. Nance, you did testify about the importance of protecting the public from harms caused by PFAS chemicals. Would you agree with me that increasing our understanding of the effects of PFAS on human health is an important aspect?
Yes.
And understanding the effects of PFAS on the environment is also important, right?
Yes.
So developing technologies to destroy PFAS contamination is also important, correct?
Yes.
And developing better methods to detect PFAS for example, in soil, water, is likewise important, right?
Yes.
So some of that research requires the use of actual requires the research of actual AFFF in a laboratory setting. Correct?
Objection outside the scope.
Mr. Nance, does this pertain to the testimony you offered here?
No, it is not.
All right.
All right. I'll move on. I think I've made my point there. Mr. Nance, from a strictly rule architecture perspective, this rule that's as proposed does require facilities that store AFFF to submit annual inventories to NMAD, correct?
That is correct.
And the rule requires facilities to maintain records of AFFF use, correct?
Maintain records of stored PFAS containing AFFF that is designated for emergency uses only.
Right. And it requires labeling of AFFF containers?
Yes.
And it requires compliance with hazardous waste storage standards, right?
It requires storage with standards that are parallel to hazardous waste storage.
So if we change the definition of use to make it clear that, for example, research activities don't qualify as use of AFFF, it is possible to do that in such a way that inventory, record keeping, labeling, storage, all those other requirements still applied, right?
Could you please state the question one more time?
If we defined the term use in such a way that excluded laboratory research, it is possible to do so in such a way that NMAD would still get reports and the facility would still have to comply with those other requirements I mentioned, such as inventory, record keeping, labeling, and storage, right?
Objection outside the scope.
Yeah. Mr. Nance, I don't remember you testifying to this point. And you can certainly speak as a regulator, not as a lawyer, if this is relevant to your testimony today. But
yeah, this was not within the scope of my testimony.
yeah, Mr. Bergmichael, you really should be making your own points and not trying to draw Mr. Nance into areas he did not testify about.
Of course, I will move on. So, Mr. Nance, you are familiar with the definition of emergency purposes in proposed section 20.13.3.7.8, right?
Yes.
And were you actually involved in drafting or that proposed definition?
Not the definition itself, no.
You're familiar that the definition says emergency purposes includes the use of AFFF to extinguish flammable liquid fires in urgent life-threatening situations. Is that right?
One second. And you should please restate the question.
Yes. So the quote I pulled here is emergency purposes includes the use of AFFF to extinguish flammable liquid fires in urgent life-threatening situations. Is that right?
May I approach with a copy of the book?
Yes, thank you very much, Mr. Roseborough.
Thank you. Yes.
But then, is it true that the definition then says, but for the purposes of this subsection, emergency purposes does not include training, testing, or the use of firefighting foam in fire suppression systems?
Yes.
So just to get it straight, under the proposed rule, the use of AFFF in fire suppression system is not an emergency purpose, right?
Correct.
And that's true even if the fire suppression system activates during an actual fire, right? Activates during an actual fire, correct?
For the purposes of the fire suppression system within a facility, it is by definition not an emergency use.
And that's true even if that fire is actually an urgent, life-threatening situation, right?
I'm not sure if I can speak to the applicability of that situation.
So, Mr. Nance, the point I'm making is the rule as written seems to prohibit fire suppression system use even during actual fires.
It only prevents the use of PFAS containing foams within that said fire suppression system,
Right.
not the suppression system itself.
Right. So if you had a fire suppression system that was currently in operation and licensed and had AFFF in it, the use of that system would not qualify as an emergency purpose per the current language of the rule. Is that right?
Yes.
Mr. Nance, are you aware how fire suppression systems work?
Sorry, I'm not an engineer.
So if I told you that they work by activating during fire emergencies, would you have any reason to doubt that?
Objection, outside the scope.
I don't remember that you testified along these lines, Mr. Nance.
I did not.
Is there another witness who would be able to, who covered this matter?
Not that I know of.
All right, thank you.
So Mr. Nance, your testimony was that you are aware of the definition of emergency purposes and that the use of AFFF containing fire suppression system is not an emergency according to the rule. And yet you're saying that you don't know if fire suppression systems activate during emergencies. I mean, I just want some common sense here. This is not a technical point.
Outside the scope. And some patterning.
Yeah, I think this is the same question, Mr. Parkamenko. We need to take a lunch break. Do you have other questions that actually relate to his testimony?
Just a few relating to the transition. The witness testified that transition is to a different non-AFFF containing system is viable. That's a direct call. And I just had a few questions on that, but probably not more than 5 minutes.
Okay, let's come back after lunch then. We'll take your remaining questions, and then in the event there's anyone here who would like to offer public comment, we'll turn to that opportunity as well. Thank you. Let's come back at 1. Good afternoon. It is 1 p.m. We're in the Aqueous foam hearing. This is EIB 25-81. Is there anyone here specifically to offer comment for the 1 o'clock comment session? Is that a raised hand? Yeah. Doreen Richards. Ms. Richards? Hello?
Good afternoon. Can you hear me?
Yeah.
Thank you. I'm hoping my camera's working, but I have no guarantees because it's a government camera system.
That's fine. Are you here specifically to offer public comment?
Yes, ma'am.
All right. If you would spell your first and last name, please.
Yes, my name is Dory. It's D-O-R-I. The last name is Richards, R-I-C-H-A-R-D-S.
Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. Please limit your comment to 3 minutes, and please speak slowly we have a court reporter trying to catch every word and possibly an interpreter as well. Go
Thank
ahead.
you. Good afternoon, Chairperson and members of the board. My name is Dory Richards, and I'm an attorney with the National Nuclear Security Administration with the Sandia Field Office. NNSA Sandia Field Office oversees the management and operation of Sandia National Laboratories, which is currently operated by NTES. One of his legal counsels is currently in the room, and that is Mr. Parkomenko. The intent of the statute and the regulations being considered here today is to prevent the discharge of AFFF into the environment with the goal of reducing or eliminating harm to citizens of New Mexico from this particular material. Historically, such discharge has occurred due to the use of AFFF as a firefighting agent, introducing it into the environment. Sandia National Labs operates pursuant to a hazardous waste permit and manages its disposal of hazardous materials consistent with that permit. The hazardous material permit's intent is to prevent the entry of such hazardous materials like AFFF into the environment where it can harm people. Sandia National Laboratories has an important research and development role, inclusive of using de minimis amounts of AFFF in its research and development, estimated at under 100 gallons per year. The material is not introduced into the environment, and its disposal has been and would continue to be performed consistent with its hazardous waste permit. The use of AFFF for R&D at Sandia National Labs does not result in discharges to the environment, to be very clear. We respectfully request that the board consider an allowable de minimis use of AFFF for research and development purposes, with the caveat that such use does not result in environmental discharge and disposal is consistent with hazardous material management permits. Thank you.
Thank you, Ms. Richards. Oh, Ms. Richards, the chair, has a question of you.
Of course.
Good afternoon, Ms. Richards. Thank you so much for being here and for providing your public comment. Do you know if Sandia was involved in the legislative session that created the statute, the enabling statute for these rules?
I would say that Mr. Parkomenko would be better placed to answer that question, Chairperson.
Okay, I don't know if now's the time, but I would like to understand if that was the case or not.
Madam Chairperson, members of the board, I don't believe that is the case. Sandia is actually restricted. We have lobbying restrictions. We cannot use, we are federally funded, and it's not allowed to use federal funds for lobbying activities, except in very specific circumstances, which I don't believe happened here. So I believe we were not involved.
So there was not a way for you to educate the legislature on the use of AFFF for research purposes at Sandia?
That is correct. We are physically not allowed to use our time to for that purpose because it's a lobbying purpose.
Okay, thank you.
Arguably.
And I can add some clarification. Is this the use of federal funds for lobbying activity is a prohibited activity, if that helps to clarify.
Okay. Thank you, Ms. Richards.
Madam Hearing Officer, this is Vice Chair.
Yes, Vice Chair Sweeney.
Yes, I have a quick question for the public commenter, if I may.
Yes.
All right. Given that Sandia has its own hazardous waste permit, would you think that, or is it possible that that permit will be revised or amended or updated to address AFFF?
Thank you, Chairperson. I can say that the most recent RCRA permit is up for renewal. It was submitted in August of 2024, and we are waiting for NMAD to take action on that permit.
Thank you. And follow-up question, will AFFF be on your side, on Sandia's side, a request to address it?
Since it was submitted in 2024, it isn't specific to AFFF in particular, but it is for all hazardous materials at the lab and its research and development activities. NMAD hasn't advised that there be any revision. And I would say that as a courtesy in the interest of comedy, when there was request from NMAD about our use of AFFF, we did provide that information.
Thank you. That's all I have.
All right. Are there other board members with questions of Ms. Richards? Does the department have any questions of Ms. Richards? Oh, Member Bitzer.
I wasn't sure when they told me my earlier question about the guy with the 4,000 head. Was this the expert who might know something about that?
I believe you were asking the department witness about that. This is a commenter for Sandia.
Sorry, I got thrown off there for a minute, so I just got back.
That's okay. That's fine, Member Bitzer. Mr. Weatherby, I was handed a note that you have questions, but I'm not sure if your questions are for Ms. Richards or for the department witness when Mr. Parkmenko is done.
Madam Hearing Officer, they are actually for Mr. Nance when the department's done. Thank you.
Alrighty, I'll call on you shortly. All right, anything else for Ms. Richards? No. All right, thank you very much, Ms. Richards. Is there anyone else online or in the room here specifically to offer comment? I will invite public comment again. It's not the only opportunity. Yeah, I think someone raised their hand. Oh, all right. All right. In that case, we're going to go back to the technical case. Mr. Parkmenko, you have a few more questions of Mr. Nance, I understand.
Just a few more questions, Madam Hearing Officer. Mr. Nance, I believe before we took the lunch break, we just concluded the line of questioning where we discussed how important it was to, for the purposes of protecting the public, to have research activities pertaining to PFAS. And then we moved on to the definition of emergency purposes in section 20.13.3.7.a in the proposed rule. So just to be clear of my understanding, I understand that under the present definition in the rule as proposed, it's okay for a firefighter to physically grab a fire extinguisher with AFFF foam and go put out the fire, putting himself in harm's way. That qualifies as emergency purposes, correct?
That is correct.
And yet, if the same function, the same fire is put out by an automated system without putting a human firefighter in harm's way, but that system has AFFF in it, that does not meet the definition of emergency purposes, correct?
Per state law, it does not.
I think that is sufficient to make my point. Thank you. I have no further questions.
All right, thank you. Anything further for Mr. Nance before I turn to the board? Oh, no, Mr.
Madam
Weatherby.
Hearing Officer? Thank you, Madam
Yes.
Hearing Officer.
Thank you.
And I thank the board as well. And Mr. Nance, first of all, thank you for the work you've done over the years. I read through your resume and the work you've done, and it's appreciated, I'm sure, by many people. And particularly your efforts to bring and help bring this important rule before the Environmental Improvement Board. You stated that you are the Bureau Chief of the NMED's Hazardous Waste Bureau. Is that correct?
That is correct.
Would you agree that one, if not the most important reason this proposed aqueous film foam forming foam containing intentionally added PFAS rule is needed is because of the presence of PFAS in that foam?
That is correct.
Okay, and does the Environment Department's Hazardous Waste Bureau have any regulatory authority regarding petroleum refineries in New Mexico?
Yes, we do over refineries themselves.
And how about
hazardous waste and within
it? Okay, sorry, I didn't mean to walk over you.
No worries.
And would that apply also to petrochemical facilities?
It would be for any facility that has a production that can generate a hazardous waste from that production.
Could you describe briefly the general scope of that jurisdiction?
I'm sorry, that's outside the scope of my testimony.
Well, okay, so let's try this here. Were you in the room when Dr. Chapman provided his testimony?
Yes.
Okay. And if it's helpful, I don't know if he had presented one slide. It was slide number 8, I believe, in which it talks about or speaks to AFFF use and statistics. It's number 8. I don't know if your NMED council could provide you with that. It was introduced or accepted as admitted as part of the record. And I wanted to ask you a couple of questions relative to that.
I object to this. That this was Dr. Chapman's testimony, not Mr. Newton's testimony.
Right.
Well, Madam Hearing Officer, if I may try to lay a foundation for this.
All right.
Okay, that particular slide deals with a reference to AFFF and its existence by percentage in various end use categories. The end use is referred to sectors. And two of the primary ones seem to be petroleum refineries and petrochemical manufacturing of facilities. And I just wanted to get clarification as to whether the Hazardous Waste Bureau would have, seeing as I do understand that this wasn't this gentleman's testimony per se, but it is about the area in which he oversees and acts as chief. And it's only a couple of more questions.
So, Mr. Nance, does this, yeah, I can see this on slide 8 here, the 20% for petroleum refineries, 21% for petrochemical manufacturing. Does this bear any relation, though, to the testimony you gave?
No, it does not. The testimony I provided was specifically to aqueous film forming foams and PFAS contained within.
All right, Mr. Weatherby, I'm sorry, I have to limit your questioning to Mr. Nance's actual testimony.
Okay, so well, one final question for Mr. Nance. Will the Hazardous Waste Bureau have any responsibilities in the enforcement of this proposed rule?
For the proposed rules, we have the Hazardous Waste Bureau specifically would have jurisdiction over any discarded PFAS containing AFFF, where that is now considered a waste under state law and rules proposed that extends to it being a hazardous waste at the state level. So yes, the Hazardous Waste Bureau under RCRA would have jurisdiction to enforce cleanup of that release.
And would that include any cleanup that is a result of that product being within a petrochemical facility or a petroleum refinery.
I'm sorry, can you clarify, is it the AFFF that would be within the
Yes,
facility?
correct.
If a facility has a PFAS containing AFFF and that is released to the environment, then that would be a enforceable cleanup action underneath the RCRA regulations.
Are you aware? Are you aware, as the current bureau chief of the Hazardous Waste Bureau, that there currently exists any AFFF product on within facilities that you currently oversee that are petrochemical or petroleum refineries?
No, object to this outside the scope.
Mr. Weatherby, again, you're drawing Mr. Nance away from the testimony that he actually gave here.
Okay, well, I will leave it there, Madam Hearing Officer. Thank you very much.
All right, thank you. Anything else before I turn to the board for their questions? Oh, redirect, anything like that?
I do have one.
All right, go ahead.
Yeah. Mr. Nance, are you familiar with section 74.15.4 of the PFAS Protection Act? I can read it to you. So 74-15-4A states that the board shall adopt rules to, this is subsection 4, as pertaining to firefighting foam, require a periodic inventory of firefighting foam quantities stored or used in New Mexico, require the use of firefighting foam for emergency purposes only, and require the cleanup of discarded firefighting foam pursuant to the Hazardous Waste Act.
Yes.
Okay, the last provision says, for purposes of this subsection, emergency purposes does not include training or the use of firefighting foam in fire suppression systems. Are you familiar with that provision?
Yes, I am.
Okay, and is it your understanding that the board can adopt rules in contradiction of this, or must they follow this?
The rule states, or the law states, that board shall adopt for those purposes and not to include fire suppression systems or testing. So I don't believe the board can adopt rules otherwise.
All right, thank you.
All right, thank you, Mr. Smith here. Chair Ely, do you have questions of Mr. Nance?
Hi, good afternoon, Mr. Nance.
Good afternoon.
Or Chief Nance. Yeah, I was looking at that section of the statute myself. I'm wondering, in the development of the two enabling statutes, 140 and 212, were you involved in the development of the language that went into both of those bills?
I was involved with the language in House Bill 140, consulted a little bit on House Bill 212, but mostly 140 was where I focused.
And in the discussion around 140, was there any consideration that you can recall around the use of small quantities of PFAS for R&D purposes?
Because of the nature of House Bill 140, it deals with a waste, not a product. So as long as that product is in use for something, RCRA regulations don't have any application in that sense. So we were focusing only on the release of.
All right, that's all for me. Oh, no, wait, I have one more question. Sorry, I forgot. You mentioned labeling in your written testimony and is part of the rule. I'm not clear what that labeling would look like. We just went through PFAS in consumer products, had a lot of discussion on what the label would look like. What would it look like for PFAS for AFFF?
So it would be very similar and consistent with what was discussed on the 212 side for a product. Or we envision that there would be labeling stating that it does contain PFAS of what the volume would be containing. So, AFFF with PFAS. If it was for emergency use, we'd likely have to see something that indicates that. that it is stored for emergency use, which makes it a product. And then once that is being, once it's moved to the side and it says, okay, we're now going to get rid of this, I'm sorry, moved to the waste side, where a facility or entity says we're no longer going to use it as a product, it's now a waste. At that moment, it would then trigger into the waste management regulations for proper storage, time for containment, and also disposal purposes. At that moment, the labeling would then trigger into contains hazardous waste, as it is identified as a waste, and then will be managed as such.
And then one follow-up question. So would it contain the very specific PFAS that's on the list of 22 new PFAS chemicals that is going into the rule, or would it just say PFAS?
I'm not fully up on the specifics, but a product should have a data sheet that will outline what the contents and what the hazards are for that volume. So they would have a data sheet that would go with that. On the label itself, it could state, you know, a PFAS containing, but also have other documentation that would outline those specific compounds.
Got it. Thank you. That's all.
Thank you, Vice Chair Suena.
I have no questions at this time.
Thank you. On the platform, Member Curry.
Yeah, I just have one point of clarification, and maybe Mr. Nance is not the one to answer it, but has the State Fire Marshal's office weighed in on this issue?
I am not aware myself.
So you're not aware one way or another. Their office hasn't taken a position.
Correct. I'm not aware if they have taken a position or not.
How about any fire departments throughout the state?
Not that I'm aware of, no.
Okay, thank you.
Member Bitzer.
Yeah, we had I had that earlier question about that potential settlement in outside of Clovis, the dairy producer who'd lost 4,000 head of cattle. Are you familiar with that case?
I am.
Has that been settled? Has the federal government made him whole, or is that still dangling out there?
I'm unaware of the status of the case. I do know that there was a case involving those parties.
And then my other question, based on the slides earlier, I don't know if this was your slide or not, but the non-toxic, I presume they're non-toxic alternatives. Maybe I shouldn't presume that, but at least less toxic alternatives. Is there comparison available as to the efficacy, how well they perform versus the PFAS containing solutions that we're out to address?
I'm not very up and specific on those actual comparisons. However, there are multiple facilities within the state and also nationwide who have transitioned to those non-fluorine based products and are using those for fighting fires and in those emergency situations.
All righty. I remember a non-toxic alternative to trivalent and hexavalent chrome, which is used to primer aircraft, which have to undergo extreme temperature and stress. They have a Roswell facility that applies, I think it was the hexavalent chrome. But anyway, it was a non-toxic alternative at a Phoenix company that actually whose product outperformed it. But folks just kept using the stuff they'd always used. So anyway, I was wondering if there was any drop off in performance. But I'll leave that question dangling in case someone else wants to pick it up later. That's all I got.
Thank you, Member Bitzer. Anything further from the board? No, council? No. Any reason not to excuse Mr. Nance?
No, but I do move to admit all the exhibits that are attached to the direct testimony.
Thank you very much. I'll pause for a moment in the event there are objections. Oh, they're admitted. Thank you. Thank you, Ms. Fernandez.
The department calls Andrew Hautzinger. Please, yeah.
Okay, if you would please spell your first and last name.
First name is Andrew, spelled Andrew, and the last name is Hautzinger, spelled Hautzinger.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Rosberg.
Mr. Hautzinger, where are you employed? I'm employed with the New Mexico Environment Department, the Water Protection Division. How long have you been in water protection? A water protection division. How long have you been employed there, and what is your current position? I've been working for the Environment Department for about 18 months. I am a lead water resource professional with a working title of Special Project Coordinator. Please briefly describe your education and professional qualifications. Very good. I have a Bachelor of Science in Watershed Science from Colorado State University. And I have worked for over 30 years as a professional hydrologist for both the federal government and the state of New Mexico. Did you file direct written testimony in this matter? Yes, I did. Do you have any corrections that you would like to make to that written testimony? Not material corrections, just noting that I did not change the header on my form to identify I'm with the Water Protection Division and not the Resource Protection Division. Thank you. With that noted correction, do you adopt that written testimony as your written testimony here today? Yes, I do. Please provide a summary of your written testimony. Very good. Let me start off by just mentioning that I submit this oral testimony on behalf of the department in support of its petition for proposed new rule 20.13.3 NMAC. Purpose of my testimony is to provide a brief overview of the most significant instances of PFAS contamination in New Mexico and to further describe the actions that the department has taken to address PFAS impacts, including testing and filtering programs for affected residents, programs for which I serve as the program manager. A copy of my written testimony and my professional resume is available in NMAD Exhibits 23 and 24. Next, I offer a summary of several of the state's most prominent documented PFAS contamination sites, all of which feature the specter of AFFF. Of highest notoriety is likely the PFAS contamination noted in 2015 at the Cannon Air Force Base in Curry County, which we've already been discussing through the proceedings, where firefighting foam created a groundwater plume affecting private wells and having significant impacts on the dairy industry in the area. Historic releases of PFAS of AFFF variety at Cannon Air Force Base created a 4-mile subsurface groundwater plume that has migrated to the southeast towards the city of Clovis and has contaminated private wells and agricultural water supplies. The department and the New Mexico Department of Health partnered on a subsequent blood study testing 628 nearby residents that revealed detectable PFAS in 99.7% of participants, and individuals residing closest to the plume exhibited blood levels up to 3 times the national average of 26%, falling into the highest exposure category. The New Mexico Environment Department has executed cooperative agreements with 4 impacted dairies, installed over 47 point-of-entry filtration systems for
point of entry hyphenated filtration systems for affected private wells, and obtained a $12 million state appropriation to extend municipal water to approximately 100 households. Another prominent example relates to an area just west of the Santa Fe Regional Airport and the Santa Fe National Guard Aviation Support Facility, where in 2023, the private wells used for drinking water by residents in the La Cienega community tested far above federal health guidelines, prompting county testing and mitigation efforts, including NMAD installation of PFAS blocking filters. Groundwater testing was initiated in November of 2023 by Santa Fe County, following PFAS detections at the Army Guard facility, with confirmed per and polyfluoroalkyl substances in 5 of 6 sampled private wells in La Cienega and La Cienega, where 3 wells exceeded EPA health advisory limits. A comprehensive 2025 study conducted by Intera Incorporated and funded by the department analyzed 82 domestic wells and 8 surface water sites, revealing PFAS concentrations reaching approximately 800 parts per thousand, parts per trillion, well above the EPA drinking water standard for PFOS and PFOA. These observations were particularly elevated in La Cienega due to local groundwater divides and and the resulting flow paths of those groundwater divides. Multimedia investigation implicated several likely sources of PFAS, including historic AFFF storage and use at the Santa Fe Army Guard facility, potential AFFF use at the Santa Fe Airport, biosolid land application, septic systems from personal systems, and effluent from the Paseo Real water reclamation facility. Short-term mitigation strategies involve private residences, point of use and point of entry, water filter installations, while long-term responses under evaluation involve drilling deeper supply wells or connecting those residences to regulated regional water systems. For my third example of AFFF related PFAS contamination in New Mexico, I'll mention the Holloman Air Force Base, which has also been a topic of conversation today, and its wastewater-fed Holloman Lake in Otero County. The observed PFAS levels there contain some of the highest recorded PFAS levels in wildlife and sediment ever, following decades of AFFF use at Holloman Air Force Base, primarily for firefighting and training since the 1970s. This has led to persistent contamination of Holloman Lake, a former wastewater evaporation basin with a complex mixture of PFAS compounds. The findings there have demonstrated significant bioaccumulation and trophic transfer, prompting species-level necropsy studies and bird nest monitoring that confirmed ecological toxicity and food chain exposure risk. Remediation plans now include delineation of PFAS plumes, integration of multiple aquatic and terrestrial media and risk assessments, and expanded groundwater well monitoring. As was noted previously, on January 7, 2025, the New Mexico Department of Health issued a health advisory to hunters and anyone who consumed or captured wildlife from Holloman Lake between 2010 and 2024. As my fourth and final example of significant PFAS contaminations in New Mexico, I highlight Kirtland Air Force Base in Albuquerque, where PFAS has been confirmed at several AFFF training areas. At Kirtland, decades of AFFF use during firefighting training and emergency response have led to soil and groundwater contaminations, particularly with PFOS, across several identified release areas. December of 2024, the Air Force submitted a Uniform Federal Policy Quality Assurance Project Plan to initiate a Phase 1 remedial investigation under CERCLA, DERP, and the National Contingency Plan. Conducted in coordination with the New Mexico Environment Department, this investigation marks a major step towards defining the extent of contamination and developing appropriate remediation strategies. Turning my attention to PFAS impacts to New Mexico's drinking water. PFAS contamination is having significant impacts on drinking water in New Mexico, affecting both public systems and private wells. There's a widespread detection across water sources. A comprehensive USGS NMAD survey in 2020 through 2021 found PFAS in all major rivers and 27 groundwater sites. PFAS concentrations in surface water reached up to 150 nanograms per liter, often driven by urban runoff and wastewater discharges. Subsequent USGS sampling in the Rio Grande near Albuquerque found PFAS concentrations 10 times higher downstream than upstream, highlighting the influence of urban wastewater on drinking water sources. Community water systems exceeding standards. Of the roughly 523 public water systems tested since 2024, 15 have registered PFAS concentrations above the new federal standards, affecting nearly 4,500 people. These impacted systems include federal, municipal, and private supplies. In response, New Mexico has launched a public dashboard, offered remediation funding, and is developing state regulatory measures as illustrated by these proceedings. Finally, in this section, I'll mention private wells and rural water infrastructure. Around 10% of New Mexicans rely on private wells, which equates to about 200,000 people. It's been said that private wells are America's hole in America's drinking water donut because they are not subject to state regulation safeguarding against contamination. That safeguarding responsibility lies with homeowners. As noted, the state has begun private well testing and filter distribution, especially near contamination sites such as Cannon Air Force Base and La Cienega in Santa Fe County. These developments underscore that PFAS contamination in New Mexico is no longer isolated to military sites. It extends to urban, suburban, and rural communities with measurable health, regulatory, and infrastructure implications. PFAS remediation and the New Mexico Environment Department's cost and administrative efforts is my next section. The Environment Department's PFAS drinking water efforts have required significant investment, including a $12 million for public water extensions and $2 million for government-provided PFAS private well filters and testing in Curry and Santa Fe County. There is a new FY26 appropriation for an additional $4 million to support residents whose drinking water is primarily provided by a private well. With private wells historically getting no government assistance, recent investments by the New Mexico government represents a substantial and growing financial commitment to protect residents relying on both public systems and private wells for their drinking water. A quick summary of related New Mexico Environment Department costs include the $12 million for the public water extensions and filters, the $2 million under a FY26 special appropriation for doing the filters installations with eligible customers in Santa Fe and Curry counties. Those filter systems go anywhere from $2,000 for the point of use systems to around $5,000 for the point of entry systems. There's this pending state appropriation coming in line next year of $4 million that I made reference to. And finally, EPA has granted the New Mexico Environment Department $18.9 million for a public system PFAS assessment to be conducted. These investments reflect significant state-level commitment to treat and mitigate PFAS exposure through infrastructure upgrades, private well evaluation, and long-term support mechanisms that support remediation as called for. Turn my attention to economic impacts caused by PFAS contamination. AFFF-related PFAS contamination in the United States and in New Mexico has created major economic burdens. Nationally, PFAS exposure linked to AFFF use is associated with annual lifetime health and productivity losses estimated at 5.5 billion to 63 billion. The Department of Defense has spent about 2.6 billion since 2017 addressing AFFF-driven contamination at military sites, with cleanup and investigation costs expected to exceed 9.3 billion through 2025 and beyond. In New Mexico, AFFF-related PFAS contamination, especially at military sites like Cannon, has created significant economic impacts. Residents face higher medical costs and lost wages linked to PFAS-related health issues. Agricultural producers have absorbed direct losses, including the euthanizing of contaminated dairy cows, and the state has invested heavily in water treatment and mitigation infrastructure to advance cleanup efforts. New Mexico is facing the following substantial economic impacts from PFAS contaminations. Cleanup and water infrastructure costs continue to decline. The U.S. Air Force Base has already spent $74 million treating PFAS contaminated groundwater at Cannon Air Force Base, contributing to a statewide military cleanup of total of $143 million. The New Mexico Environment Department has incurred more than $12 million in legal, technical, and remediation expenses and has committed another $12 million in 2025 to extend public water service and install private well filters in Curry County. Agricultural losses. PFAS contamination has had especially severe consequences for agriculture. At Highland Dairy, near Cannon Air Force Base, PFAS tainted water accumulated in livestock to dangerous levels, forcing the dairy to euthanize 3,665 cattle. This single event resulted in an estimated 5.95 million in losses, excluding carcass disposal and other associated costs, and illustrates how PFAS can directly wipe out food-producing herds, destabilize family operations, and truly put a strain on rural economies. Together, these reflect millions in direct cleanup and infrastructure costs, multi-million losses in agriculture, and significant legal expenses, underscoring a profound economic burden on the state. Finally, I provide these concluding remarks. In summary, PFAS contamination is widespread across New Mexico, and its impacts on public health are becoming increasingly clear. The PFAS mixtures that communities worry about most, both long chain and short chain compounds, are typically the ones found in AFFF. While pinpointing exact PFAS sources can be technically challenging, the evidence shows that AFFF is the primary contributor in the contamination cases described above. Over the past 6 months in Curry County and the La Cienega, La Cienega communities, I've managed a program offering free PFAS testing and filters to residents who rely on private wells for their drinking water. That work has meant hundreds of one-on-one conversations, mostly by phone, but also in person and through email and text, with people worried about what's coming out of their taps. Their stories have stayed with me. Many describe feeling unsafe in their own homes, afraid their water may be harming them. I've heard again and again about serious illnesses and even the loss of loved ones that families believe may be tied to AFFF-related PFAS contaminations. These conversations have made the human impact of PFAS impossible to ignore. One community member in La Cienega told me, "My family and I feel we can be forgiven for assuming that the reason we are getting sick is because we unknowingly drank PFAS-contaminated water for years. In the past 5 years, I have lost 3 of my 5 brothers to different forms of cancer. Our family is convinced that AFFF-related PFAS played a role, yet we feel despondent that science and government policy have not caught up and that our concerns are too often dismissed as speculative." Another powerful memory of mine was sitting in the living room of an elderly lady in La Cienega, whose eyes moistened as she pointed to her rack of mason jars containing fruit from her yard's fruit trees. And she said, "For years, I've been harvesting the fruit from these beautiful trees and giving them to my family as Christmas gifts. Now, with what we are beginning to learn about this firefighting foam, I need to toss all those jars into the trash while fearing that my past gifts might have gotten loved ones sick. Beyond health concerns, residents often tell me about the financial strain PFAS contamination has created. Many are stretching tight budgets to buy bottled water for everyday needs. Others are watching their property values plummet because they rely on private wells, and PFAS in their water makes their homes harder to sell. The anxiety around this is real. One Curry County homeowner told me his assessed property value had dropped by 75%, a loss he directly attributes to PFAS contaminated well water. Stories like his underscore how PFAS doesn't just threaten health, it destabilizes families' finances and their long-term security.
Thank you. Mr. Hausinger is available for questioning.
Thank you, Mr. Hausinger and Mr. Roseborough. Are there questions of Mr. Hausinger based on his testimony?
I see Mr. Weatherby noted on the forum.
Mr. Weatherby?
Yes, Madam Hearing Officer, thank you very much. Just two questions. Thank you for your testimony, Mr. Hausinger. You mentioned their testing is being done in private wells and water systems. Are you aware of testing that's been done in either Lee County or Eddy County by the department?
I am not.
Okay, and the last question is the testing being primarily focused as it relates to PFAS on AFFF, or is it more general as far as the inclusion of PFAS in water?
My response to that is, I believe we followed the risk, and the examples I brought are high risk examples that are related to AFFF. So I don't think there was an explicit decision on the part of the department to only focus on AFFF. It's just that was the nature of the contaminations that we were being presented with.
Okay, thank you very much. Thank you, Madam Hearing Officer.
Thank you, Mr. Weatherby. Anything before I turn to the board, Mr. Roseborough?
No.
No? All right. Member Bitzer, would you like to begin the board questioning of Mr. Hausinger?
Well, I was impressed by the human toll that he accounted for. He gave me further clarity on the fellow that I talked to about a year and a half ago who lost his dairy ranch or farm, I guess you call it, with 3,600 plus heads of cattle. But no, that was good. I have no questions.
All right, thank you. Member Curry, do you have questions?
No questions.
Thank you. Madam Chair.
Just, yeah, good afternoon. I asked Dr. Chapman this question, and I think you're the better person to respond. I'm just wondering how we got started on these investigations. I'm glad we did, but what came to light, say, in 2015 when we first started really diving into the PFAS issue to prompt the investigations, to look at groundwater, to look at wildlife and cattle? Do you know what prompted that?
As at the time I was a hydrologist with the Fish and Wildlife Service in 2015, I've only heard second or third hand how the early days of the Curry County contamination happened. So I don't really know what the original incentive was to do the original round of testing, but it certainly seems to me that very early on in those proceedings that there became a disconnect between the state and federal partners, and we stopped working as closely together as we typically would, and here we are 10 years later with that same challenging dynamic, which my lawyers tell me, hey, you weren't asked that question, so why are you saying anything? But I can speak to the Santa Fe Airport and the National Guard instance. There was an original observation in the early 2020s at the GARD facility, and there's individuals in Santa Fe County who wondered how far to the west that contamination would have migrated off of the airport property. And so they did their own independent testing, Santa Fe County did, and then provided those numbers to us and asked us to partner. So that's kind of how we've gotten where we're at today in this county.
It just seems like there's just so much potential to find PFAS in many different environments, in many different mediums. And it's like, is there something like epidemiological studies or something that can help us focus? You mentioned following the risk. We know AFFF is a risk, and so potentially wherever we know that was used, it could be a method for identifying sources that need further investigation.
No, I think that's very astute on your part, Chair.
That's all. Thank you.
Yes.
All right, thank you. Vice Chair Sweeney, do you have a question? When she left the platform, she said she was going online, but she may have stepped away. All right. Any reason? Oh, there you are. Do you have questions of the witness, Vice Chair Sweeney?
I don't have any questions. Thank you.
All right, thank you. Any reason not to excuse Mr. Hutzinger?
No, Madam Hearing Officer. Thank you, Mr. Hausinger, and I move the admission of all the testimony and exhibits associated with this testimony.
I'll pause for a moment in the event there's an objection. They're admitted. Thank you.
Thank you.
Thank you, Mr. Hutzinger.
The department calls Dr. Kyle Staggs.
Would you spell your first and last name, please?
Yes, it is Kyle, Kyle, Staggs, Staggs.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you, Mr. Roseberg.
Good afternoon, Dr. Staggs. Where are you employed?
I'm currently employed in the New Mexico Environment Department.
How long have you been employed there, and what is your current position?
I've been employed there since November of 2024, and my current position is the Resource Protection, Compliance and Enforcement Bureau Chief.
Please briefly describe your education and professional qualifications.
I first attended undergraduate in University of New Mexico in their chemical engineering program. And I went from there to Arizona State University, where I did my graduate work also in chemical engineering and finished defending my doctoral thesis at that time at Arizona State University. And that intervening time, I was a professor in engineering and then came to work for NMAC later.
Thank you. Did you file direct written testimony in this matter?
I did.
Do you have any corrections that you would like to make to that written testimony?
I do not.
Do you adopt that written testimony as your testimony here today?
I do.
Okay. I'd like to start by discussing the rules record keeping requirements. How will the department enforce record keeping requirements in the new rule?
The department is going to enforce these record keeping requirements by incorporating these into our existing hazardous waste inspections.
So this is a normal part of the process for what we do for any other sort of hazardous waste. We're looking to do records inspections and make sure that we understand what these facilities have, that they are handling them appropriately in the appropriate timelines in accordance with the guidelines that are outlined within the Hazardous Waste Act.
How will the new rules labeling requirements be enforced?
The labeling requirements are going to be enforced very similarly to other labeling requirements. As it is, we have to observe that facilities are keeping track of what it is that they have, that they are labeling them in accordance with the Hazardous Waste Act. They have information, including the hazardous waste label itself, information about what the contents are, documentation available so that we can assess what it is and that they're handling it appropriately.
Thank you. How will the AFFF inventory requirement be enforced?
The inventory requirement is going to be enforced in a very similar way to what we are looking for in terms of the timeline for hazardous waste. And what that means is we have certain timelines that have been established under the Hazardous Waste Act for how long they can store materials, things of that nature. And what we are trying to do is we are trying to make sure that we know what, as we work our way through inspecting these facilities, we're trying to ensure that we are able to begin building out these inventories of what they're going to have on hand, what amounts they have, what quantities, if the information is available, how long they've had it, so that we have an idea what is actually present at all of these different facilities. So it'll likely take some time to build out that inventory process. If they don't have it on hand, we would treat that just like other missing records in a normal hazardous waste inspection, where they would have an opportunity following a notice from us to get us that documentation, and there would be a required timeline for compliance. Typically, that would be through a document called a notice of violation or an NOV, and that's a mechanism that we use as kind of a first step to get the information if they hadn't provided it to us as part of the exit conference when we're done with one of those on-site inspections.
What happens when or if facilities do not comply with an NOV and they are still in violation?
If they are still in violation, this is where we're going to bring in something like an administrative compliance order. These are fairly uncommon for many facilities in our experience. It's fairly typical for a facility to find out that they're missing something and to make good faith effort at providing us the documentation and whatever other information that we're seeking as part of that. And this gives us the opportunity to work with the facility to bring them back into compliance before bringing penalties into the situation or something like that. In this case, ACO would give them a more strict timeline with more detailed corrective action to compel them to come back into compliance within a specified time frame in a more formalized legal sense.
Thank you. Do you have any other statements to make regarding the proposed rule?
Only a brief one. The proposed new rule implements certain mandates of the PFAS Protection Act, which establishes crucial compliance measures, including record keeping, annual inventory, and labeling requirements for any facility which obtains, manufactures, stores, or uses AFFF products containing intentionally added PFAS. The established enforcement process overseen by NMED's Resource Protection Compliance and Enforcement Bureau outlines clear steps involving the notices of violation and administrative compliance orders. In addition, the revised rebuttal rule outlines the emergency only use for AFFF rather than for use in training to better protect human health and the environment.
Thank you. No further questions. Dr. Staggs is available for questions.
Thank you very much, Dr. Staggs and Mr. Roseborough. Are there questions of Dr. Staggs?
Madam Hearing Officer?
Yes.
I have no questions. I would like to thank Dr. Staggs for his work and on behalf of the people in New Mexico. Thank you.
Thank you. Member Curry, would you like to begin our questioning?
I have no questions, Madam.
All right, thank you. Member Bitzer?
I've got no questions. Thank you.
All right. Vice Chair Sweeney?
I have no questions.
All right. Chair Ely?
No questions.
Council?
You thought you were done.
Sorry.
So following up on the question I asked Dr. Chapman earlier, so then with the reporting requirement that you described, at some point, New Mexico will be able to determine the nature of the stockpile.
I believe so, and I believe that was part of the intent of the way that the rule itself, the actual law, was structured. That's my understanding.
All right, thank you. That's it.
Okay. Anything further, Mr. Roseborough?
No, I move the admission of Dr. Staggs' testimony.
All right, I'll pause for a moment. Hear no objections, they're admitted. Thank you very much. Thank you, Dr. Staggs.
Thank you, Madam Hearing Officer and members of the board.
That concludes testimony for the new rule.
Would it be good to take a short break?
Yes, Madam Hearing Officer.
All right, let's come back at 2:20. Come back from the break, please. Mr. Roseborough.
Thank you. And so just to signpost us, we're now moving on to the department's proposed amendments to 20.4.1, specifically those made pursuant to HB 140. And with that being said, I'll call Dr. Ranjana Dangi.
Good afternoon. Would you spell your first and last name, please?
Yes, my first name Ranjana, Ranjana, Dangi, Dagi.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you so much, Mr. Roseborough.
Good afternoon, Dr. Dangi. Where are you employed?
New Mexico Environment Department.
How long have you been employed there, and what is your current position?
Almost 2 years. I started in May 11 of 2024, and my current position, Senior Environmental Scientist.
Thank you. Please briefly describe your education and professional qualifications.
Yeah, I would like to start with my undergraduate degree. I did complete my bachelor's degree majoring environmental microbiology and chemistry minoring. And then I moved forward with my master's degree in analytical chemistry from my country, Nepal, Tribhuvan University. After that, I moved here at University of New Mexico to pursue my PhD degree, and where I completed my PhD degree in mostly focusing on organometallic and organic chemistry. And after that, I briefly worked as a postdoctoral scholar under the National Science Foundation scholarship. And then before I joined, I also worked as an instructor at Central New Mexico Community College.
Thank you. Did you file direct written testimony in this matter?
Yes.
Do you have any corrections that you would like to make to that written testimony?
No.
Do you adopt that written testimony as your written testimony here today?
Yes.
Okay, please provide a summary of your written testimony, and I'll move your first slide.
Okay, so I'm here to testify my written testimony based on the Triple AFF Association of Listed Chemicals and the associated non-toxicity of the listed chemicals. Okay, on my first slide, I have listed the chemicals, and these chemicals are associated with the AFFF based on the research studies and independent investigations performed by different research groups using the samples or investigation unit as the AFFF use area or the infected community and the blood as human serums of the infected communities.
Thank you.
Yeah, moving forward, I'm going to explain in brief the associated toxicity, non-toxicity of the each chemicals one by one. So the number one chemical listed in my testimony is the perfluorooctanoic acid, and I have also presented the snapshot for the chemical structure of that chemical. And this chemical, when we expose, this is actually highly investigated and studied chemical, and it causes the chronic kidney damage and thyroid disease, the hormonal disbalance, and autoimmune disease. It increases the cholesterol level, and it reduces the effectiveness of vaccines, especially in the kids, and it causes the cancer and the pregnancy-induced hypertension and systemic inflammation for the, it affects overall body. And it is very toxic to the liver, and it causes cancer to the liver as well, based on the research even I have cited on the bottom of this slide. And the immunosuppression showed that causes the increased infection, especially to the children, and the low birth weight for the newborn babies. And just I want to point that these associated toxicity has been also supported by the safety data sheet. I have put the snapshot there to support its toxicity to the human body and environment.
Thank you.
Number two listed chemical is the PFAS constituents of AFFF products in my written testimony is perfluorooctane sulfonic acid. And similarly, I have put the snapshot of that chemical on my slide. And this chemical is also highly investigated and very toxic based on the independent research and investigations. And it causes the immunosuppression in mostly in childhood if they are exposed even in their mother's body or outside in early time. And it causes the dermatitis and slow down. It causes respiratory infections, and it is highly toxic for the kidney, and it is carcinogenic and hazardous to the environment. It has detrimental effect to the ecosystem and food chain for the environment. And similarly, I have there to support my associated toxicity from the safety data sheet, and I have put the snapshot of that showing irritant, hazardous to the human health and the environmental hazard. Number three chemical listed in my written testimony, which is associated with AFFF products, is perfluoroheptane sulfonic acid, and structure it as shown there as a snapshot. And the associated non-toxicity based on the research and investigations are immunosuppressions, which is very common in other PFAS as well, like I mentioned before. Fatty liver disease, and it alters the gene expression, which causes causes to synthesize or produce non-functional protein and dysfunctional protein, so affects the overall human health. And necrosis, which kills the cells. Inflammation, like the overall body internal organ inflammation, and liver damage, which is very common for these PFAS constituents, to damage the soft tissues, and liver is the most important target there. And this compound is a synonym for the perfluoroheptane sulfonate. And both of them have the same CAS number. So we are going to revise for that to keep only the top one, only the headlines one, and going to remove the bottom one because it's just the same CAS number, but we use twice repeatedly in our original rule. Number 4, constituent in my listed testimony is perfluorohexane sulfonic acid. The structure is shown in the top, and it causes very common like other. It damages the liver, it damages kidney, and other regular organ functions, like very important organ functions. And also is toxicity characteristics has been supported by the safety data sheet published by PubChem, and we can see the corrosive and irritant as its associated characteristics. Number 5th chemical PFAS constituent associated with AFFF I have listed in my written testimony is perfluorobutane sulfonic acid. As the structure is shown in the top as a snapshot, and seems like repetitive, but these compounds mostly affect to the liver, so it also does. It does the liver toxicity and endocrine disruption. And that means that this chemical interacts with the hormone and then disrupts overall metabolic and chemical processes, biochemical processes inside the human body, and it changes the organ weight, then the normal weight, and impacts overall biochemical parameters. That means it alters the human serum or chemistry of human serum. And its characteristics is also supported by the safety data sheet published by PubChem, and which is corrosive and irritant. So the number 6 chemical listed in my written testimony is perfluoropentane sulfonic acid, as shown in the structure, just differ by 1 carbon membrane. And their number 5 and number 6 are very similar in their toxic characteristics. So it also does, it is also toxic to liver. It disrupts the endocrine functions, interfering with the hormones, and changes the organ weights. So then it's normal, and alters the serum chemistry that directly affects the biochemical processes inside our body, and it is hazardous to the environment that affects detrimentally to the food chain and the ecosystem. And similarly, this toxic characteristics has been supported by the safety data set produced or published by PubChem, is corrosive and irritant. Number 7 chemical I have listed as PFAS constituent in the AFFF product in my written testimony is perfluorodecane sulfonic acid, a chain with the 10 carbon member. And with this being a very long chain, it has very high tendency for the bioaccumulation. That's why it affects more organs, and it does immunodisruption, oxidative stress. It reduces the antioxidants, and which causes to have a more radical particles inside our body, and which directly attacks the organ or other parts. and inflammation. It causes the systematic inflammation of different our internal organs. The one is covered by that one. Yeah, so. Oh, yeah. So the negative effects on the gene expression and yeah, actually there was 1 point on the top.
Thank you, sir. Okay. So you were on number 7. correct?
Yeah, number 7. Yes, now I got it. The last one is alters lipid metabolism. So yeah, now we got it. Lipid metabolism that causes to generate the non-functional and dysfunctional proteins that affects overall our health. It affects negatively for the biometabolism, but biochemical processes inside our body. Yeah, now I'm 8. Number 8 chemical I have listed based on research on my written testimony is a PFAS constituent associated with AFFF products is perfluorohexanoic acid, and which is also very toxic, very similar to number 1 and number 2 of listed chemicals in my written testimony. So it damages kidney and reflux injury. It causes reflux, which causes the damaging of the esophagus region, and it is hepatocellular hypertrophy. It causes the increased size of the hepatocellular cells or liver cells, and it causes negative effects on expression, gene expression, and enzyme activity, like very similar to the other negative effects on the biochemical activities of the cells. And the other thing is toxic characteristics has been supported by the safety data sheet published by C. Malrich as a corrosive and dangerous. Number 9 chemical in my written testimony I have included is PFAS constituent associated with AFFF product is the perfluoroheptanoic acid, and it is 7 carbon member chemical compound. It burns the skin, it damages the eye, it increases liver weight, and decreases the serum lipids, which these affects overall to the human regular functioning activities. And its toxic characteristics has been also supported by the safety data sheet published by PubChem, and which is showing it is hazardous to the overall human health. Number 10 chemical or PFAS constituent I have put in my written testimony is associated with AFFF product perfluorohexanoic acid, and which is also very toxic, very similar toxicity with PFOA and PFOS. Those are on number 1 and 2 in my written testimony. So it causes the chronic kidney damage, and it causes thyroid disease, and it causes the autoimmune disease, just to our own immunity system attacks to our system, like a type 1 diabetes. It causes the cancer to different internal organs, and it causes the high cholesterol level in our body, and it reduces the other effectiveness of immunization in the children. And the most important, very toxic, being very toxic, it causes the systematic inflammation of the overall internal organs to damage, or it does the complete organ failure. And its toxicity characteristic has been also supported by the safety data sheet published by PubChem, and which is corrosive, irritant, and it has the overall hazards to the human health effect. Number 11 chemical, on number 11, the chemical I have listed in my written testimony is perfluoropentanoic acid. The structure is shown there. And based on the research done by the researchers and peer review articles, it is corrosive. It does the liver enlargement, like the same thing, other increase the size of the liver, and it causes the disruption of endocrine by interference of this chemical with the hormone, and it causes the immunotoxicity directly affecting the immunity, so increasing the chance of having infectious disease. And the toxicity characteristics has been supported by the safety data sheet as corrosive. Number 12 chemical listed as a PFAS constituent in my written testimony is AFFF associated chemical is perfluorodecanoic acid, or 10 carbon member chain. And based on the research or peer review articles, this chemical causes the oxidative stress. That means it reduces the antioxidants and increase the level of radicals that attach to the organs. Immunoactivation, that immunoactivation is the rapid response immunoreaction, so without the specific organ or without the target, so it affects multiple organs. Increase liver weight, again, is very similar to other chemicals. Decrease the serum liquids, so it does have negative consequences on overall our metabolic processes, and it causes the neurotoxicity and locomotor impacts. That's mostly these impacts to the development of child for their fine motor skills, their motion, and their controlling and activity. And the toxicity of these chemicals has been also supported by the safety data sheet, which is showing this chemical can cause the overall health hazards to the human being. Number 13 chemical I have listed in my written testimony, perfluorotriidecanoic acid, is the 13 carbon member chain. And based on the research, the known toxicity for this chemical or associated with this chemical is corrosive. This chemical is irritant, and it causes the oxidative stress, as I explained before, and it induces the autophagy induction, which has negative impact in our overall health. And the toxicity characteristics also has been supported by the safety data sheet, as this chemical is corrosive, irritant, and it does have overall health hazard impact to the human body. So the number 14 chemical I have listed here is perfluorodecanoic acid, and the structure I have put the snapshot on the top. And based on the research and the findings, the non-toxic characteristics for this chemical are: this is corrosive, this chemical is irritant, it causes hepatotoxicity, it does have lipid peroxidation. Is also directly related to the metabolic activities, and it causes neurotoxicity that is mostly focused on the central nervous system and the dopamine pathways, which blocks the dopamine that transmits the message for the motion. And the toxic characteristics also has been supported by the safety data sheet published by PubChem, is corrosive and irritant. Number 15 chemical in my list in the written testimony is perfluorotetradecanoic acid. The structure has been shown there, long carbon chain there. And the toxic characteristics based on the research and independent studies have been presented here as corrosive, and this chemical is irritant, and it causes the oxidative stress, and it has the property of stimulation of cell apoptosis. And the toxic characteristics also has been supported by the safety data sheet, as this compound is being corrosive, irritant, and it does have health hazards to the overall human health. Number 16 chemical I have listed in my testimony is N-methyl perfluorooctane sulfonamide, and the structure has been shown on the top. And the study has shown this compound as an irritant, and it shows the developmental toxicity based on the study performed on the zebrafish having the similar genetic feature with the human. And the toxic characteristic is supported by the safety data sheet as an irritant. Number 17, chemical as a PFAS constituent in my written testimony is N-ethyl perfluorooctane sulfonamide acetic acid. The structure has shown on the top as a snapshot. And based on the research, the associated or non-toxicity when we expose to this chemical is carcinogenic. It does affect, it is a reproductive toxic to reproductive systems. And another important fact about this compound, these compounds break down easily into the products, which are PFOSA, or we also call PFOS or PFOA, and which are the number 1 and number 2 chemicals in my list. So the toxicity also comes from these degraded or the biodegraded constituents, components. And number 18, chemical constituents I have listed in my written testimonies: N-methyl perfluorooctane sulfonamide acetic acid. And based on the research findings and investigation, this compound is toxic to overall humans and toxic to the aquatic environment. And again, these compounds break down into PFOS, which adds additional toxicity, because this PFOS is number 2 listed chemical in my written testimony. And this toxicity characteristics also has been also supported by the safety data sheet published by OSHA, and which shows the irritant overall negative impact or hazards to the human health, and it is hazardous to the environment. Another chemical is a number 19 I have listed in my written testimonies for fluorotelomere sulfonic acid, which FOH2 is FOH2 depends on the number of carbon chain, and the ring starts with a functional group. And this chemical, based on the research, is corrosive, and this chemical is irritant. It has the toxic effect to overall human health, and it does have this chemical does have the toxicity to the overall development. And toxic characteristics has been supported by the safety data sheet published by PubChem, and which is corrosive, irritant, and it has the health hazard characteristics associated with it. Number 20 chemical I have listed in my written testimony is fluorotelomere sulfonate with 6:2, again based on the number of carbon. And this chemical is corrosive and irritant, and it causes the immunotoxicity, and it does have negative effect on the development. So it causes the developmental toxicity, and it is toxic, hepatotoxicity. And also its toxic characteristics has been also supported by the safety data sheets presenting this compound is hazards is corrosive, irritant, and hazard to the human health. Number 21 chemical I have listed in my written testimony is fluorotelomere sulfonate, 8:2. The structure has been shown there. And this chemical is corrosive. It causes the organ damage, and it does also show the oxidative stress and mitochondrial dysfunction, which causes the energy disbalance and organ failure. And it also causes the metabolic disruption to also associated with the negative impact on the metabolic process. And the safety, the toxic characteristics also has been supported by the safety data sheet as an overall negative or the impact hazards to the human health and is corrosivity. Number 22 chemical I have listed in my written testimony, perfluorooctane sulfonamide. The structure has been shown there on the top, and this chemical is acutely toxic, and this chemical is irritant, and it is hazardous to the environment. It causes the developmental toxicity, and it is neurotoxic. It is toxic to the neurons or nervous system. And another last one, this chemical easily biotransfer into the PFOS, like the number 2 chemical in my listed written testimony. So the toxicity also comes from those biodegraded or biotransformed products. And additionally, the toxic characteristic has been also supported or presented by the safety data sheet published by PubChem. This is the corrosive 8010, and it has negative impact to the overall environmental health.
All right. Thank you, Dr. Dangi. Dr. Dangi is available for questions.
All right, thank you. Questions in the room here? Mr. Parker-Banco.
I just have one question. So, Doctor, you've described many of the potential health effects of these substances. But if the substance never comes into contact with the person, then we don't actually have to worry about any of these, right? If there's no release in the environment.
Yes, if no release or we are not directly exposed. Yes.
Yes, no further questions. Thank you.
All right, thank you. Mr. Weatherby, do you have a question?
Yes, just one which I'll probably have ruled out of order. But Doctor, first of all, thank you for a really fascinating testimony and your hard work. These
You are welcome.
all, hello? Yes, can you hear me?
Yes, I do.
Okay. Well, again, thank you. Just one quick question. Many of these PFAS-related chemicals, are they not also found in places other than in AFFF?
I will object.
Yeah.
Because it was associations with AFFF specifically.
Right. Mr. Weatherby, for better or
Okay.
worse, we're here about AFFF.
I understand. This is the Environment Department that's bringing this, and I just wanted to at least ask that question. Thank you, and I'll stop there.
All right, thank you. Let me go to the board. Member Curry, do you have any questions of Dr. Donkey?
No, I do not.
All right, Member Bitzer? I'm not hearing you, Member Bitzer, if you're speaking. All right, Chair Ely?
I don't have any questions, but thank you for your testimony.
Thank you very much for this opportunity.
Vice Chair Sweeney?
Thank you, Madam Hearing Officer, and thank you for your testimony, Doctor. And I don't have any questions.
All right, thank you. Anything further, Mr. Rosever?
No redirect. I move the admission of Dr. Dangi's testimony.
All right, I'll pause for a moment. They're admitted. Thank you very much. Thank you very much, Dr.
Thank you very
Donkey.
much.
Okay, next the department calls Janosh Walters, and I'm going to share another PowerPoint, so please give me one moment. So,
Would you spell your first and last name, please?
Yep, Janosch is Janosh. Last name is Walters, Wolters.
And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Roseborough.
Good afternoon. Thank you for being here. Where are you employed?
Eastern Research Group.
How long have you been employed there, and what is your current position?
I've been employed by Eastern Research Group for approximately 5 years, but split between 2 time periods. I took about a year and a half after 4 years of working for Eastern Research Group, and I worked for EPA headquarters as a rigor inspector and engineer.
Thank you. Please briefly describe your education and professional qualification.
I have a bachelor's of science degree in energy engineering with a minor in environmental engineering, and I've been primarily supporting PFAS cases for the last 6 years.
Thank you. Did you file direct written testimony in this matter?
I did.
Do you have any corrections that you would like to make to that written testimony?
I just have one correction. I mentioned in my written testimony, specifically regarding the concentration-based standards, that each analyte would have to receive a non-detect result. NMED had made, I guess, a revision or an update to that, and it includes the concentration for PFOS and PFOA at 4 parts per trillion, and the remaining analytes listed in the proposed amendment would require a non-detect result.
Thank you. With that correction in mind, do you adopt that written testimony as your written testimony here today?
Yes.
Okay, please provide a summary of your written testimony.
Thank you. So a summary of my written testimony is specifically to the amendment in 20.4.1.801 regarding the land disposal restrictions. So first I'll start off with an overview of the land disposal restrictions. In this case, if a generator were to be land disposing of hazardous waste, AFFF here that would require the generator to then have certain land disposal restrictions applied to that waste. They would have to identify the waste code being used, either NMF1 for spent AFFF or NMU1 or unused AFFF meant to be discarded. Then the land disposal restrictions would point us to determine a treatment standard. NMED has proposed to allow generators flexibility by using 2 different treatment standards. Generators can either decide to use a technology-based standard or use a concentration-based standard. Once the generator demonstrates compliance with one of those 2, it would be determined that the treatment standard would be met, and therefore the waste or the residual of the waste from the treatment would be eligible for land disposal under RCRA Subtitle C. Next slide, please. Thank you. So as I mentioned earlier, NMED allows for a concentration-based standard. If a generator decides to demonstrate compliance.
Your call has been forwarded to voicemail. The person you're trying to.
Oh, no worries. So if a generator decides to demonstrate compliance with the concentration-based standard, they would be required to conduct sampling of the waste, send the samples for analytical testing. And when they review the analytical report, they would need to ensure that the concentrations observed in the analytical report meet the concentration-based limits set forth in the proposed amendment. For PFOS and PFOA, that's set at 4 parts per trillion, and the remaining analytes are required to have a non-detect result. NMED further defined that a non-detect result means that the concentration did not exceed the method detection limit. The method detection limit can simply be thought of as the lowest level a lab can confidently state that a chemical is present and not zero. Once the Once all those requirements are met, then the treatment standard would have been met, and therefore the waste would now be eligible for land disposal under RIPRA subtitle C. NMED also provided an option for generators to demonstrate compliance through a technology-based standard. This would just require the generator to treat the waste by one of the approved technologies. NMED has proposed either using combustion or incineration for non-wastewaters, or for wastewaters, they propose using combustion, incineration, or carbon absorption. Once the generator can show that the waste has been treated by one of the approved methods, the treatment standard would be met, and therefore the residual waste from that treatment would now be eligible for land disposal under RIPRA subtitle C. So I'll just finish off with that the proposed amendment to 20.4.1.801 will reflect a clear and concise path forward that provides multiple options for generators to use to demonstrate compliance. It protects human health and the environment with fair, accessible, and reasonable treatment and disposal methods already approved by EPA that is used for other wastes. Remains adaptable to future improvements and analytical methods and to treatment technologies that may enhance in efficiency and environmental performance.
Thank you, Mr. Walters. He's available for questioning.
Thank you, Mr. Rosberg. Questions in the room?
No
Mr. Wedding?
questions. No questions,
right.
Madam Hearing Officer. Thank you.
Thank you. Chair Ely, do you have questions of Mr. Walters?
No questions, but thank you, Mr. Walters.
Vice Chair Sweeney.
No questions, and thank you.
All right, on the platform, Member Bitzer? No. Member Curry?
No questions. I noticed that, okay, Barry said he has no questions. I see just now, just popped up.
Oh, okay.
But I have no questions.
Thank you. Any reason not to excuse Mr. Walters?
No, and I hereby move the admission of his testimony.
All right, I'll pause for a moment in the event there's an objection. They're admitted. Thank you very much. Thank you, Mr. Walters.
Thank you.
Okay, the department has a final witness, Mr. Aaron Kaufman, who will address the reauthorization amendments to 20.4.1 and the single proposed amendment to 20.4.3.
Would you spell your first and last name, please?
My first name is Aaron. Last name is Coffman.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Rose.
Mr. Kaufman, good afternoon, and thank you for being here. Where are you employed?
I work for the State of New Mexico Environment Department.
Thank you. How long have you been employed there, and what is your current position?
I've been with the New Mexico Environment Department for the last 12 years. My current position for the last 3 years has been as the program manager for the hazardous waste section of the Resource Protection, Compliance, and Enforcement Bureau.
Please briefly describe your education and professional qualifications.
I have a bachelor's degree in Earth and Planetary Sciences from the University. Earth and Planetary Sciences. And like I stated before, I've worked with the state of New Mexico for several years, and I've inspected many of the facilities here in New Mexico.
Thank you. Did you file direct written testimony in this matter?
Yes, I did.
Do you have any corrections that you would like to make to that written testimony?
No.
Do you adopt that written testimony as your written testimony here today?
Yes.
Okay. Please provide a summary of your written testimony.
Thank you very much, Madam Hearing Officer, members of the board. As I stated before, my name is Aaron Kaufman. I present this testimony today in my role as the program manager for the New Mexico Environment Department, or NMED's
hazardous waste section of the Resource Protection, Compliance, and Enforcement Bureau, providing an overview of the necessary technical revisions to New Mexico's hazardous waste management regulations, as was requested by personnel with the United States Environmental Protection Agency, or US EPA, Region 6 Office. Additionally, this testimony addresses other technical revisions presented in NMAD's proposed amendment to 20.4.3 NMAC or NMAC. As I stated before, I actually have 16 years of professional experience between consulting and also working with the New Mexico Environment Department for the last 12, including 9 of those years as a hazardous waste inspector, and the last 3 being in the position of program manager for compliance. In my role, I coordinate with environmental regulatory stakeholders, including the US EPA. NMED also receives some of the funding for regulation, permitting, and enforcement of hazardous waste management from a grant as an authorized state, and receives other consultation with the US EPA under an existing memorandum of agreement. My testimony provides a high-level orientation on important concepts in the framework of authorization by the US EPA, including the Federal Resource Conservation and Recovery Act, revisions to New Mexico's hazardous waste program to retain our authorized status, prospective adoption of federal regulations, and how the newer e-manifest provisions clash with existing definitions, and other technical revisions of the regulations observed to be necessary following review with the US EPA. The Resource Conservation and Recovery Act, or RCRA, RCRA, was signed into law in 1976, establishing a federal framework for regulation of waste under the authority of the US EPA. RCRA includes provisions for the states to obtain authorization so that they can carry out their individual programs. Concurrently, the New Mexico legislature passed the first iteration of the New Mexico Hazardous Waste Act in 1978. The Hazardous Waste Act is similar in many respects to RCRA, and also establishes the procedures by which the board promulgates regulations that are utilized by the NMED to execute the state's hazardous waste program. Since 1990, this program has maintained our authorized status with the US EPA, and we've worked diligently to safeguard New Mexico's people and environment. And as the regulations promulgated federally and at the New Mexico state level have evolved over time, New Mexico's hazardous waste program has also changed. US EPA requires states to revise their hazardous waste programs to maintain at least an equivalency with the national program. NMED receives a grant from US EPA as one of the funding streams for administering its program as an authorized state. And part of my role is the development and execution of an annual work plan for those authorized activities. One of the tasks assigned by US EPA is the adoption of updated regulations that are more stringent than New Mexico's existing ones. In February 2024, the US EPA requested that NMED perform a revision of its hazardous waste program to incorporate recent updates to the National Hazardous Waste Management Program, including hazardous waste pharmaceuticals and the new e-manifest system, and to submit documentation to US EPA for renewal of our authorization. In 2018, the board promulgated prospective adoption of the federal hazardous waste regulations in accordance with the New Mexico statutes. Prospective adoption means that New Mexico's hazardous waste management regulations are kept current and automatically adopt any newer regulations in the relevant sections to the incorporated references in 20.4.1 NMAC. Thereby, New Mexico has already adopted into its regulatory structure all of the relevant provisions of the hazardous waste management regulations as requested by US EPA. The remainder of my testimony will focus on the background for those outstanding technical corrections we still need to do for 20.4.1 NMAC that were requested by US EPA, the rationale for those technical corrections, and the correction of a typographical error in 20.4.3 NMAC. NMED coordinated with US EPA to identify areas of our regulations where, as prospectively adopted through 2024, the term substitutions that are found that clarify the state's hazardous waste regulatory authority infringe on the National Uniform Hazardous Waste e-Manifest system and other technical corrections. The e-Manifest system was established to modernize the hazardous waste tracking process in the United States. New Mexico has been working with the US EPA to properly administer the state-level functions of the e-Manifest system as part of our authorized hazardous waste program. These changes and relevant updates to the e-Manifest implementing regulations, which are contained in several provisions, which are incorporated by reference in parts of 20.4.1 NMAC and prospectively adopted, sometimes detail requirements that are not meant to be delegated to the states. The primary example of this is import-export functions, which are intended to be administered at the federal level and have never been a part of any state's authorized program. However, there are also multiple functions in the e-Manifest system, as hosted by US EPA, that are not administered by the states, but are directly implemented by US EPA in the new e-Manifest national system. Because New Mexico incorporates the hazardous waste management regulations from the Code of Federal Regulations with modifications, it has always been necessary in these adoptions to modify them by substituting terms. The purpose of these substitutions is to ensure that NMED is the authority in these regulations under our state program. However, with updates to the regulations at the federal level, it has caused some prospectively adopted regulations to improperly identify NMED as the responsible authority in some areas. Consequently, US EPA requested a series of technical corrections to clarify terms for these functions in several locations of the regulations, as detailed in my written testimony. The next technical correction is an addition to the modifications of New Mexico's incorporation of 40 Code of Federal Regulations, or CFR, Part 260 at 20.4.1.101C to omit incorporating 40 CFR 260.2, which discusses environmental information received from the public and regulated entities under these regulations. The omission of 40 CFR 260.2 was noted as a necessary technical correction by US EPA staff. NMED therefore will handle all information received in the course of its administration of the hazardous waste program, pursuant to existing New Mexico law governing document disclosure and confidentiality. Also, during consultation with US EPA and considering the terms used due to inconsistencies in the prospectively adopted NMAC, US EPA requested that New Mexico clarify the definition of qualified professional engineer in 20.4.1.201B NMAC to mean, quote, an independent New Mexico licensed professional engineer in accordance with the New Mexico Engineering and Surveying Practice Act, sections 61-23-1 through 32, NMSA 1978, as amended, end quote. US EPA also noted 2 locations in the NMAC where there was insufficient language to support the function of prospective adoption, specifically at 20.4.1.900C1 and C2 for public notice requirements during hazardous waste permit applications. NMED determined that these sections had been inadvertently left unchanged during the rulemaking action in 2018 and should have been amended at that time. US EPA recommended that each provision be clarified with the phrase, as it may be modified or amended when incorporating these 2 federal regulations. Also, one of the relatively major changes to the National Hazardous Waste Program in the interim between the last update in 2018 and today is US EPA's promulgation of standards for the management of aerosol cans as universal waste. This is actually an area that New Mexico has been a pioneer on, as since the year 2000, New Mexico has allowed generators of waste aerosol cans to manage these wastes as universal waste when managed for recycling. US EPA standards that they have promulgated only more recently are similar to New Mexico's pre-existing requirements. However, they are slightly more stringent in that they do explicitly require aerosol cans to be protected from sources of heat. Since the state authorization framework requires that we be at least as stringent, and since we have already prospectively adopted the newer regulations, US EPA has requested that we delete duplicative and conflicting requirements. Thank you. NMED concurs with this assessment. All of the requirements previously found in this section are reflected in the prospectively adopted federal regulations. Also, to ensure consistency with how the New Mexico Hazardous Waste Program regulates the labeling of universal waste, including aerosol cans and other universal wastes, US EPA has requested adding the example wording spent aerosol cans to the list of alternative universal waste labeling requirements of 20.4.1.1001B NMAC. US EPA staff also identified a small number of other necessary technical corrections, consisting of pluralization of terms regarding import-export notices and citation corrections. Also, during review of potential technical issues within the NMAC in need of correction, and during the administration of the hazardous waste program, NMED discovered an apparent typographical error that was present in the most recent prior rulemaking in this section from 2020. At that time, the board approved an updated schedule of hazardous waste annual and business fees. These fees are essential for the proper functioning of the hazardous waste program, the resiliency of the program to properly manage environmental challenges, and to reduce the burden on the state and federal taxpayers for its implementation. The board promulgated provisions in 20.4.3.202C NMAC and at 20.4.3.402C NMAC to provide a fair balance for New Mexico industry, that the updated fee schedules that were adopted at that time could be adjusted annually for inflation. Unfortunately, the provision in 20.4.3.202C NMAC has the incorrect citation, where it should be referring to the section immediately before it, saying that hazardous waste annual fees could be adjusted for inflation, and would cite that schedule as 20.4.3.201 NMAC. It instead cites 20.4.3.401 NMAC, which is the schedule of the business fees. This, in effect, makes 20.4.3.201C NMAC and 20.4.3.402C NMAC identical. NMED believes this was an inadvertent typographical error during the prior rulemaking submittal. As currently structured, NMED is unable to adjust the hazardous waste annual fees for inflation. These make up by far the majority of the fees collected between the two in this section. To ensure NMED is preserving the original intent of the rulemaking effective in 2020, NMED respectfully requests correction of this typo in 20.4.3.202C NMAC as to cite 20.4.3.201 NMAC. Thank you very much for your time, and I hope you do approve these rules. Thank you.
Thank you, Mr. Kaufman. Madam Hearing Officer, Mr. Kaufman is available for questioning.
Thank you very much, Mr. Roseborough. Mr. Kaufman, are there questions in the room? Mr. Weatherby?
Yes, Madam Hearing Officer. I have one question. Thank you, Mr. Kaufman. Just the last testimony you gave relative to the typographical error am I reading that to be that that's been the case since 2020, that that's been out of compliance with what the intent was?
That's my understanding, yes.
And thank you. So that this rulemaking would not provide for any recouping of what got missed for the last 5 or 6 years. Is that fair to say, or do you understand that to be the case?
I'm not sure if that's something that I've looked into at this time or that the department's made a determination about.
Okay, well, thank you. And do you know if there's any provision forward going to try to correct these, collect these things and get them squared away sooner than a 5 or 6 year period?
If I understand your question correctly, what we're doing today is trying to correct this error so that we can move forward as was the original intent of the rulemaking to adjust in the future.
Okay, all right, thank you. And thank you, Madam Hearing Officer.
Thank you, Mr. Weatherby. Let me turn to the board. Chair Ely, do you have a question?
No questions. Mr. Weatherby's cross cleared up my question. Thank you.
All right, Vice Chair Sweeney.
No questions. Thank you.
Thank you. Member Curry
No questions.
and Member Bitzer.
Get it at Shamrock and those things. But there's some of the drinks, the sodas that we get, like the big packs for the price.
Yeah. All right. Yes. Seems like he was having audio issues earlier.
Mr. Member Bitzer, can you unmute yourself? We show you as not being locked or anything.
Just sticking with that.
Okay, we see you.
Can you hear me?
See. Yes.
You should be able to hear me too.
Yes, we can.
Yeah, I was able to hear earlier, and I had no questions for the earlier presenters, but for some reason I was blocked. But now I'm unmuted, and I got video back, so I think we're good.
Do you have questions of Mr. Kaufman?
No questions.
Thank you so much. All right, anything further, Mr. Roseborough?
Nothing for Mr. Kaufman. I move the admission of his testimony.
I'll pause for a moment. It's admitted with all attachments. Thank you. Thank you very much, Mr. Kaufman.
Thank you.
We should take a break. Let's come back at 3:40 and we'll talk about where we're going from here. I might request an oral closing argument of you. All right.
Yes, Madam Mayor.
Thank you so much. 3:40. We are back after a short break. Mr. Rosebrew, would you like to offer a brief closing statement?
I would. Thank you, Madam Hearing Officer, Madam Chair, and members of the board. Today, you've heard important testimony regarding 3 proposed rulemaking actions: the adoption of 20.13.3 NMAC, the amendment of 20.4.1 NMAC, and the amendment of 20.4.3 NMAC. In all 3 cases, the department has met its burden of providing sufficient technical testimony to provide the board the opportunity to adopt the proposed regulatory changes in full. As for Rule 20.13.3, you heard testimony regarding the mandates of the PFAS Protection Act. Specifically, that the board is required to implement rules requiring a periodic inventory of AFFF quantities, requiring that AFFF be used in emergency purposes only, and requiring that cleanup of AFFF be made pursuant to the Hazardous Waste Act. We started with the testimony of Dr. Chapman, who explained the science of PFAS, how it impacts the health of New Mexicans and the environment of New Mexicans. Then we moved on to John David Nance, who provided testimony about the legal rationale for the adoption of 20.13.3, the processes by which the rule was drafted, and the legal grounding for each provision of the proposed new rule. While he was up here, while he was on the stand, John David Nance also described the importance of a state-run hazardous waste program as required, or as proposed to be amended in 20.1. We then had Mr. Hautzinger join us on the stand and talk about the human and financial costs of AFFF contamination to New Mexico. We heard the impacts to New Mexicans' health, the impacts to their property values, the costs that the state has incurred providing clean drinking water to New Mexicans impacted by AFFF contamination. It provided compelling evidence why this matters and why time is of the essence here. Then you heard the testimony of Dr. Kyle Staggs. Dr. Staggs described that the department is prepared to administer proposed new rule 20.13.3. The administration of it, at least in the enforcement context, will be folded into existing inspections. The department is prepared from the day this rule is active to administer it and enforce it. Then we moved on to the proposed revisions to 20.4.1 made in accordance with House Bill 140. You heard the testimony of Dr. Ranjana Nanji, who described in detail why the department chose each of the 22 PFAS chemicals it did. It associated with AFFF. Each of those 22 chemicals is listed in 4 sections of the rule: 20.4.1.201 D, E, and F, and 20.4.1.801 C. It's my opinion, or I believe, that Dr. Dongi's testimony sufficiently showed that 1, each chemical constituent is associated with AFFF, and 2, that each chemical is toxic. And because she showed both of those, they are legally warranted for inclusion in the department's core list that is proposed in 20.4.1. Then following Dr. Dongi, we called Janos Wolters. Mr. Wolters provided testimony on the treatment standards that will be used by the department in cases where AFFF is deployed in emergency circumstances. The department is giving generators of AFFF multiple options here. They can treat to non-detect if they're able. If they're not able, generators are able to choose depending on water or wastewater, one of two or one of three treatment technologies. Generators have options here. This is a reasonable, economically reasonable and technically feasible choice that the department is giving generators of AFFF here. It's just an utterly reasonable revision to the rule. Finally, we heard evidence from Aaron Kaufman. Mr. Kaufman walked the board in detail through the reauthorization process, why it's important, why the state needs to handle its own business, and the specific changes that were requested to bring the state of New Mexico's regulations in line with the EPA's regulations. His testimony, including his exhibits, showed why each reauthorization change was made in accordance with the request of the EPA. And I think he provided persuasive evidence that each one of those requested provisions is necessary and appropriate here. And finally, Mr. Kaufman provided evidence about the proposed single amendment to 20.4.3. He provided, I believe, persuasive evidence that the department needs to be able to charge fees adjusted for inflation to keep up with the costs of administering its hazardous waste program. I'll just end by saying that, as you heard in Mr. Hausinger's testimony, New Mexicans who are impacted by AFFF contamination are suffering. In a previous hearing, you heard the phrase, turn off the spigot. We're trying to do the same thing here. It's of the utmost importance that AFFF only be used in absolutely emergency circumstances. The department takes it very seriously, its role and responsibility to help New Mexicans have a clean, healthy environment for us, for our children, for our future. And so I thank you for your time and attention in hearing the department's testimony. I'm happy to answer any questions, but I'll conclude with that. Thank you.
Thank you. Any reason not to close the evidentiary record at this time? No, thank you. The record is closed, and I will pass the gavel, imaginary gavel, to Chair Ely. Thank you.
Thank you, Department, for your testimony. So the next step in this process would be moving on to deliberations. And I'm going to propose to the board that we actually deliberate this afternoon. That we've got, I believe, enough time, an hour, to deliberate on this matter. And we have the testimony fresh in our minds. We had very little opposition, one concern coming from Sandia Lab, which I think we can address in our deliberations. And so I'm going to propose that we take this opportunity to deliberate now. I would like, though, to hear from the other board members to see if they concur with that. I see a thumbs up from Mr. Bitzer. Member Curry, are you okay deliberating now? Okay, good. Vice Chair?
Yes, I'm okay.
Okay, great. So I would like to take up the one point that was brought up by Sandia and have a discussion around that. Through their public statement, their oral statement, their written comments, and through their cross, they were making the point that a small amount of PFAS that is carefully controlled in the lab and disposed of properly should not be prohibited under the rule. And they may have even been arguing that it should be considered under emergency purposes. So what and to me, I would support using PFAS, as a research tool so that we can better understand how to mitigate PFAS, how to destroy PFAS when we need to. But I need to get a legal opinion from council about whether PFAS for research R&D purposes can be used under the statute as it is currently written.
Thank you, Madam Chair. I think the simple answer is no. If you look at the statute 74-15-4, subparagraph 4, I think the language is really clear. And as you've heard in many other rulemakings, the board is limited by statute. And I don't see any authority in the statute to do anything other than require the use of firefighting foam for emergency purposes only.
That's how I read the statutory language as well. So in order to actually, for Sandia to accomplish what they're trying to accomplish, they would actually have to go back to the legislature, get language put in the statute to enable the department or any other petitioner to come forward to make modifications to the rule to allow PFAS for the purpose of research and development. That's my understanding.
I think you're right, Madam Chair.
Thank you for that clarification, legal counsel, and for the question, Chair. And I just want to reiterate that anybody can come to the board for that to look at and have an amendment to the rule in the future as well. And understanding, I think in public comment, we heard from Sandia's attorney that there was some issues with lobbying the legislators. So I don't know how that would work, but just wanted to note that as well.
Yeah, that's correct. All right, so let's see, on the platform, Member Bitzer, Member Curry, do you have any questions or concerns about that last topic of discussion? No.
Madam Chair, and maybe this isn't the right place, but I'm going to go back to a question that I asked earlier. I'm a little bit, if not, I'm not baffled, but I'm concerned that throughout this question, we have not heard from the state fire marshal or any of the fire departments that would be using this material, as far as it's, aside from the PFAS question, is just how this will affect their operations at all. And so that's just a concern I have, and I think it's relevant, but there seems to be a void there.
Yeah, it's a good point, Member Curry. Perhaps they understand the hazards related to this material and the heartache it's brought to a lot of communities in the state, and are willing to move forward with just its use as an emergency in an emergency situation.
Well, knowing your background and your efforts in that area, the fact that there is completely no expression from any of the firefighters or the firefighting efforts in the state, I'm going to take that as what you just said is that their silence indicates support, but it still strikes me as unusual.
I have a note here from Pam saying that Dory Richards is on the platform and has raised her hand to speak. We cannot accept any more evidence at this point. So, Ms. Richards, I think that I'm at this point, we are deliberating and not taking any more public statement or evidence into the record. It's closed. So board members, are there any other items related to the two proposed amended rules or the new rule that you would like to bring up for discussion at this point? I don't have any um, concerns or items that I'd like to bring forward to the board. I feel pretty comfortable with what we heard today and would be ready to take a vote on the adoption if the other board members are as well. All right.
Yes, I'm supportive of moving forward.
Okay. So do I hear a motion to adopt amended Rule 20.4.1 modifications, exceptions, and omissions related to aqueous film forming foam, and amended Rule 20.4.3 hazardous waste fees, as well as adoption of the new Rule 20.13.3 NMAC aqueous film forming foam for the reasons stated in the department's statement of reasons as filed with the petition. And I'm going to allow council to make a clarification.
I would note the department issued a notice of errata as to 20.4.1, and perhaps any motion to adopt could be made also subject to the contents of the notice of errata.
Council, could Mr. Rosenbaum, could you please explain the errata real quick?
Absolutely. So in Dr. Donkey's testimony today, and the chemicals are complex, so let me make sure I say the names correctly. Okay, thank you for your patience. So in Dr. Donkey's testimony today, you heard her say that perfluoroheptane sulfonic acid and perfluoroheptane sulfonate are synonymous. They use the same chemical identification number. Specifically in 20.4.1.201E, the department submitted a rule which regulated perfluoroheptane sulfonate. Everywhere else in its list of 22 chemical constituents, the department used the phrase or the chemical name perfluoroheptane sulfonic acid. And so we hope that all four lists of those 22 chemicals in the rule are identical. And so we submitted that notice of errata, noting that that was an inadvertent error, and they all should all refer to perfluoroheptane sulfonic acid.
Yeah, I recall her stating that the case number is identical between those two.
Yes, yeah. Madam Chair.
Yeah. All right, good. Let's clear that up. We want to, it's complicated enough without having two different names for one chemical, right? So, so do I hear a motion about adopting the amended rules and the new rules, including a consistent term for perfluoroheptane sulfonic acid throughout the rules?
I'll adopt that as my motion.
And I'll second.
All right, great. Thank you for that. Let's take a vote on that, and then I'll do a couple more cleanup motions after that. Pam, would you like to do a roll call vote on Member Bitzer's motion?
I will. Member Bitzer, what is your vote?
I vote yes.
Thank you. Member Curry?
Vote yes.
Chair Ely?
Yes.
And Vice Chair Spina?
Yes.
Motion passes.
Thank you. And then perhaps a motion that will enable NMAD to work with state archives to format the new rule and amended rules, and also enable me to sign the statement of reasons once it is ready.
May I make that into my motion? I move to address those two items.
I'll second
Is there a
that.
second? Great, thank you. Pam, will you do a roll call vote on that?
Yes, could you restate that motion for me, please, Chair?
The motion was to more with formatting that, right? Oh, yeah, to direct the Bureau to work with the state records.
Got it. Okay.
As well as to allow Chair Ely to sign.
Yeah, I got that part. Thank you. Appreciate that. Okay, Member Bitzer, your vote on that motion?
I vote yes.
All right, Member Curry,
Yes.
Chair Ely,
Yes.
Vice Chair Sweeney.
Yes.
Thank you. The motion passes.
Great. Great. We're done with that agenda item. Madam Hearing Officer?
Yes, I have one question for Member Curry and Member Bitzer. How are you, this unrelated to anything we've done today, how are you fixed for the week of September 21st for a hearing on the heat rule?
Too soon to tell, but let's say yes. I'll say, you know.
Thank you.
I had to find my phone. Hang on. I can find the right screen. September what?
21st. I wouldn't necessarily expect it to take, 4 days, but that's how long I'll set it for.
I'm open the 21st of September.
Great, thank you so much. And the 22nd.
Yes, 22nd as well.
Okay, thank you. Thank you, Cherry Lee. That's all I wanted to do.
It's good to get those things on the calendar. So the last agenda item is next meeting, and that will be April 24th. And we'll have a hearing on food fees, our regular monthly meeting. I know there's a couple petitions to consider, one being from the Petroleum Storage Tank Bureau. And I believe you're all said you would all be available then. Our numbers are dwindling, so we need to make sure we have a quorum. So I'm hoping that all 5 members can attend that hearing and that meeting.
Yeah.
Is there anything else we need to discuss today before we adjourn?
No, I just wanted to know, I have it on my calendar.
Oh, great.
The 24th.
Great. Pam, what's the location of that meeting? And hearing?
This room. Yep, room 321 on April 24th.
Getting pretty comfortable in here. Yeah. All right. Thank you all. If there's nothing else, I move that we adjourn. Thank you.
I'll take that motion.
Okay. We got a few more days we didn't know we would have, so enjoy them.